Honorable Conchita Carpio-Morales in her capacity as Ombudsman versus the Court of Appeals, 6th Division, and Jejomar Erwin S. Binay Jr. Appearing as counsel for petitioner are the following: Acting Solicitor General Florin T. Hilbay, Assistant Solicitor General Hermes L. Ocampo, Senior State Solicitor Raymond I. Rigodon. Appearing as counsel for private respondent are the following: Attorney Claro F. Certeza, Attorney Mariano Sarmiento II, Attorney Maria Patricia L. Alvarez, Attorney Jose Julius R. Castro, and Attorney Sandra Marie Olaso Coronel. That's all.
The parties' counsels are hereby advised that you are still under the same advisory dated April 7, 2015. And as manifested during the last session, Attorney Certeza will argue on items A, C, D, E, and F, and Attorney Coronel will be arguing on items B, G, I, J, and K. And as provided in the same advisory, the presentation is already dispensed with, and we will begin with the interpellation by the justices. Counsel may please take your seats, and we will begin by the interpellation of Justice Bernabe.
Good afternoon, Counsel. Okay.
Good afternoon, Your Honor.
My first question is, what is the basis of the authority of the Court of Appeals, or any court for that matter, to issue a temporary restraining order?
If Your Honor, please. The basis for the power to issue a temporary restraining order or writ of preliminary injunction is Article 8, Section 1 of the Constitution. Whenever there is grave abuse of discretion, the courts have the power over instrumentalities of government to stop such abuse, Your Honor.
How about the rules of court? Would you consider it as a source of power to issue a TRO?
Yes, Your Honor. The Court of Appeals, under Rule 135, if I remember correctly, has the power to issue a TRO or writ of preliminary injunction.
Okay. Is the issuance of a TRO a matter of jurisdiction or a matter of procedure?
I would believe that it is procedural, Your Honor, please.
Okay. Would you agree that under Section 5 of the Constitution, the Supreme Court has the sole power to promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, and therefore it cannot be taken away by Congress?
I fully agree, Your Honor.
Now, how do you reconcile now the plenary power of Congress to define, prescribe, apportion, and limit the jurisdiction of statutory courts, such as the Court of Appeals?
Your Honor, please. Insofar as apportionment of jurisdiction is concerned, we submit that that is within the province of Congress. But then, if we are already talking about the manner of enforcement of such right, it goes into the rulemaking power of the Supreme Court, Your Honor.
So you are saying that once subject matter jurisdiction is conferred by law, the courts are inherently empowered to issue ancillary writs to carry out its jurisdiction and to enforce order in proceedings before it?
Yes, Your Honor.
Okay, and we have the rules of court. Would you go over Section 6, Rule 135?
Yes, Your Honor, I have it with me.
Okay, can you read Section 6?
Section 6 means to carry jurisdiction into effect. When by law jurisdiction is conferred on a court or judicial officer, all auxiliary writs, processes, other means necessary to carry it into effect may be employed by such court or officer.
Okay, you stop there. How about Section 5 of Rule 135?
Inherent powers of courts. Every court shall have the power, A, to preserve and enforce order in its immediate presence, B, to enforce order in proceedings before it or before a person or persons empowered to conduct a judicial investigation under its authority, C, to compel obedience to its judgments, orders, processes, and to the lawful orders of a judge out of court in a case pending therein, to control, in furtherance of justice, the conduct of its ministerial officers and all other persons in any manner connected with the case before it, in every manner appertaining thereto. E, to compel the
Okay,
attendance
that's all. Do you think that the power to issue a TRO is essential to the court's exercise of judicial power?
Yes, very essential, Madam Justice, because without such power, then there might be no compliance to the order.
And the status quo will not be maintained.
Yes, Your Honor.
Now let's go to Section 14 of the Ombudsman's Act. The first paragraph, will you read the first paragraph? Or anyway, what does the first paragraph refer to?
I believe it refers, Your Honor, to a restriction regarding the issuance of the writ of injunction, Your Honor.
Okay.
If there's going to be a delay, then the first paragraph says that it is prohibited, Your Honor.
Okay, how about the second paragraph?
It talks about an appeal, Your Honor. And it says, no court shall hear any appeal or application for remedy against the decision or findings of the Ombudsman except the Supreme Court on pure questions of law.
Okay. And when you speak of application for remedy, what does it exactly refer to? Can it refer to an injunction?
I do not think so, Your Honor. But it is my understanding of the law that when it talks about application for remedy, it has something to do with the appeal that
Okay.
is being referred
So
to.
are you assuming that there is a final decision of the Ombudsman under the second paragraph?
Yes, Your Honor.
Now, assuming that Section 14 of the Ombudsman's Act is constitutional, would you agree that the prohibition is only against a TRO which has the effect of preventing or delaying the investigation of the Ombudsman?
Your Honor, with due respect, my position is considering that it does not specify, I would venture the opinion that it refers to a TRO or preliminary injunction.
Yes, a TRO or a preliminary injunction, but the prohibition is if it has the effect of delaying the investigation of the Ombudsman. Is
Yes,
that
Your
correct?
Honor.
Now, and as an exception, a TRO or an injunction may nonetheless be issued if there is a prima facie evidence to show that the subject matter of the investigation is outside the jurisdiction of the Ombudsman. Is that correct?
Yes, Your Honor.
Do you think that the issuance of an injunction against a preventive suspension will automatically result in the delay in the investigation of the Ombudsman, or is there a necessity to provide justification for it?
I don't think that the effect is automatic that there is a delay, Your Honor.
So there has to be a justification. Is that what you mean?
Yes, Your Honor.
Okay, in this case, you claim that the injunction issued by the CA did not delay the Ombudsman's investigation. Is that correct?
Yes, Your Honor.
But would not the lifting of the preventive suspension order impede the Ombudsman's access to the documents in respondent's custody, and as such, would have the effect of delaying its investigation.
It is our submission that the power to investigate and the power to preventively suspend are two different matters, Your Honor, please. The investigation can proceed with or without the preventive suspension, Your Honor.
But what would you say about the fears of influencing the witnesses and tampering the evidence on record if the official stays in power?
I think that is a matter of evidence, Your Honor, please.
Okay. Now, on the assumption that the CA's power to issue an injunction can be withheld by Congress, and it is found that the injunction would delay the Ombudsman's investigation, does the main certiorari case remain with the Court of Appeals?
I would believe so, Your Honor.
And the only effect would the case before the court would only refer to the nullification of the injunction.
Yes, Your Honor.
Now, assuming that the CA's injunction is nullified on the basis of Section 14 of the Ombudsman's Act, can the court issue a TRO against the Ombudsman's preventive suspension order?
The Supreme Court, Madam Justice?
Yes, counsel.
I would believe so, that the Supreme Court has every authority and right to issue a
But what
preventive.
is the basis for your answer? You have no prayer for the issuance of an injunction against the Ombudsman's preventive suspension order before the court.
I would always go back, Madam Justice, to Article 8, Section 1
So
of
do
the
you have a
Constitution.
prayer for the issuance of an injunction before the court?
I'm sorry, Madam Justice, I did not get the last question.
Do you have a standing prayer now before the court to issue an injunction against the preventive suspension order?
Before the Court of Appeals, Madam Justice?
Before the Supreme Court.
No, Your Honor, we are the respondents here, Your Honor, please.
That's why in case the TRO, the injunction is nullified on the basis of lack of jurisdiction, you do not have any prayer for the issuance of an injunction before the court.
I don't believe so, Your Honor. Our prayer, Your Honor, is for the dismissal of the petition for certiorari filed by the petitioner and other just and equitable reliefs.
Okay.
that
Now,
are
the
paid
case
for.
before the court is a certiorari proceeding to determine first if the Court of Appeals has no jurisdiction to issue an injunction against the preventive suspension order, and if the injunction raised by the CA was issued with grave abuse of discretion. Do you agree with that?
Yes, Your Honor.
Now, shouldn't the court's determination of grave abuse of discretion be limited only on the Court of Appeals findings stated in its resolution ordering the issuance of an injunction?
I believe so, Your Honor.
What is the court's basis for enjoining, the Court of Appeals' basis for enjoining the Ombudsman's preventive suspension in its resolution?
Based on the resolution of the Court of Appeals, which is now before this honorable court, one ground is the failure of the Ombudsman, being the respondent there, to follow doctrinal pronouncement, particularly doctrinal pronouncement on condonation. In addition to that, Your Honor, another basis for saying that there is grave abuse of discretion was the fact that the resolution was done in haste, Your Honor. And there was really no serious consideration given to the facts of the case, Your Honor.
Okay. But of course, the court is not precluded from threshing out all issues relevant to the disposition of this case.
As far as this honorable is concerned, my answer is yes, Your Honor.
Now, assuming that this court can review this case beyond the Court of Appeals' application of the condonation doctrine, do you think that the Ombudsman complied with the requisites for the issuance of a preventive suspension order under Section 24 of the Ombudsman's Act?
It is our submission, Madam Justice, that the Ombudsman did not.
Okay, what are the requisites for the issuance of preventive suspension order?
The essential requisite, as far as this representation is concerned, is that there must be strong evidence to justify the issuance of a preventive suspension order.
And you think there is no strong evidence?
Yes, Your Honor.
No. Was the respondent given the opportunity to file its comment to the administrative charge before the preventive suspension order was issued?
I think, Your Honor, the preventive suspension order was issued ahead before the respondent in this case.
Do you think it was necessary for the respondent to make its comment for the Ombudsman to determine whether or not the evidence of guilt is strong?
It would have been desirable, Your Honor, that
But not necessary.
I went over one case where it was said in that way, Your Honor.
Okay. What does the phrase evidence of guilt is strong mean? Should you equate it to substantial evidence, or prima facie evidence, or less than substantial evidence?
I would think, Your Honor, that it should be substantial evidence because the person who will be preventively suspended will be effectively deprived of his duty to serve his the electorate who elected him.
Wouldn't substantial evidence be enough to already elevate or to impose a sanction, an administrative liability for that matter?
I'm sorry, Madam Justice, are you asking if it is enough?
No, I was asking you the quantum of evidence to determine whether or not the evidence of guilt is strong, and you are saying it's substantial evidence.
Yes, Your Honor.
And I'm replying by saying that isn't substantial evidence enough to impose an administrative liability?
I would believe so, yes, Your Honor.
Now, what is your basis for saying that the evidence against respondent is not strong?
If the records will be examined, Your Honor, first and foremost, a perusal of the relevant dates will show that the respondent herein is being held accountable for some actuations that even occurred before he was elected mayor. And with regards to other allegations of wrongdoings, these were committed at the time that the respondent was performing his first term, and because of his re-election, the theory of condonation tells us that he cannot be administratively held liable.
Were there no wrongful acts committed during his term?
During his first term, there was an alleged wrongful act, and by virtue of his re-election, it is our submission that it is covered by the theory of condonation, Your Honor.
Okay. What is respondent's right in esse that would that gave the CA that gave the CA grounds to issue an injunction?
It is not more of the respondent's right in esse. It was what this honorable court referred to, I think, in the case of Garcia, where the Supreme Court acknowledged, Your Honor, that if you put an elected official in preventive suspension or by way of suspension as a penalty, then it is a great disservice to the electorate, and for that reason, there should be good grounds for it.
Okay, your comment and your petition in the main invokes the condonation doctrine. Is that correct?
Yes, Your Honor, and Madam Justice, if you will permit, on the area of condonation, Attorney Coronel, we have agreed that she
All
will
right.
answer.
Can
Is
I
that all
ask
right?
Attorney Coronel to
With the
please
court's
approach
permission.
the podium. Okay.
Good afternoon, Your Honor.
Good afternoon, Attorney Coronel. Attorney Coronel, in order to condone something, you must first be aware of what you are exactly condoning.
Well, Your Honor, with all due respect, all the cases that we have examined applying the principle of condonation, Your Honor, already establishes that actual knowledge of the acts of the elective official is presumed in the re-election, Your Honor. Therefore, it is our humble submission that actual knowledge is not required to be established for the invocation of the doctrine of condonation, Your Honor.
So based on existing jurisprudence, you can condone something that you do not know.
Yes, Your Honor, this is a legal fiction, Your Honor, which our court has established as early as 50 years ago, Your Honor.
Okay. Is the condonation doctrine applicable if what is involved is merely a preventive suspension order, which is only a preventive measure and not a liability determination?
Yes, Your Honor, we humbly submit and refer the court to its previous rulings, where the court specifically directed the Court of Appeals, reminding it of its duty to render assistance to, in the event of grave abuse of discretion committed by the Office of the Ombudsman, in the face of the fact that the condonation doctrine was not appreciated by the Office of the Ombudsman in a preventive suspension case, Your Honor.
Okay. Assuming that the condonation doctrine is overturned by the court, how would this affect the CA's disposition of the main certiorari proceeding?
Well, Your Honor, I would...
In short, should the doctrine be applied prospectively, retroactively?
Well, Your Honor, the principle of law will always be a prospective application, Your Honors. However, at this point, Your Honor, there is yet no occasion, specifically in this case, it is humbly submitted for the court to review the condonation doctrine, Your Honor. After all, this is a Rule 65 petition where the only issue is grave abuse on the part of the Court of Appeals. The respondent humbly submits that the opportunity to revisit the doctrine of condonation will have to await a proper case filed before this court on a Rule 45 when the an error of judgment is alleged in an appeal, Your Honor.
Okay, that would be all, counsel.
Thank you very much, Your Honor.
Justice Carpio.
Attorney Coronel, I have some follow-up questions on condonation.
Good afternoon, Your Honor.
Who has the power to condone or pardon a penalty in administrative disciplinary cases? Who has the power to condone or pardon a penalty?
Justice Carpio, can I just have a feedback whether the audio is good enough? Is it good enough at the back? Okay.
Who has the power to condone or pardon a penalty in administrative disciplinary cases?
Your Honor, invoking the ruling of this court, the power to condone is an inherent power attached to the inherent power of the electorate, Your Honor. Therefore, it is the electorate, Your Honor, we submit.
Have you come across Llamas versus Orbus, where the court said that for the executive branch, it is the president who has the power to condone or pardon a penalty in administrative disciplinary cases, because this is implied from the power of the president to condone or pardon in criminal cases after final conviction.
Yes, Your Honor. However, if we recall, Your Honor, this particular case involves an administrative penalty, Your Honor. It is only the condonation is being made only applicable to the administrative penalty, Your Honor.
Yes,
the power
that's
to
why.
condone. Yes,
Well,
sir.
it's clear the Constitution says the president has the power to pardon after conviction in a criminal case. In Llamas versus Orbus, this court said there is an implied power here for the president to pardon or condone penalties in administrative cases for the executive branch, correct?
Yes, Your
So
Honor.
the power to condone or to pardon penalties in administrative cases is a presidential power that emanates from the power of the president under Section 19, Articles 7 on pardoning of in criminal cases, correct?
Well, yes, Your Honor.
Okay. Now, the power to condone is a constitutional power of the president, in other words, insofar as the executive branch is concerned. Correct?
We admit, Your Honor.
For employees in the judiciary, the power to condone or to pardon is lodged in the Supreme Court. We have rules in so many cases, correct?
Yes, Your Honor.
And in Llamas versus versus Orbus, this court said, for employees of Congress, the power to condone or to pardon is lodged either in the House or in the Senate, correct?
Yes, Your Honor.
Okay. Just like in criminal cases, the court said in Llamas versus Orbus, the power to condone or pardon in administrative cases can be exercised only after the respondent is adjudged guilty of an administrative offense, after the decision has been rendered, correct?
Yes, Your Honor, after the decision has been
Okay.
granted.
Now, can Congress authorize a government official in the executive branch other than the president to exercise the power to pardon in administrative cases?
I'm sorry, Your Honor.
Can Congress pass a law authorizing another government official other than the president to exercise the power to pardon in administrative cases?
Because this is emanating from the constitutional power of the President, Your Honor, then we submit that
Cannot
Congress
be done.
cannot. Yes, Your Honor.
Yes. Can Congress authorize a group of persons, whether private or governmental, to exercise the power to pardon in administrative cases? Cannot be also.
Yes, Your Honor.
Can this court authorize a group of persons, private or governmental, like, let's say, the voters of a local government, to exercise the power to pardon in administrative cases?
Well, Your Honor, this court has.
Yes.
In Pascual, Your Honor, as enunciated repeatedly over the past 50 years, Your Honor.
Yes, this court, but remember, that was a 1935 case, correct?
Yes, Your Honor. So recently,
Under the 1935 Constitution.
yes, Your Honor, but this was
And under the
recently.
1935 Constitution, there is no statement that public officials shall be accountable at all times to the people, correct?
Yes, Your Honor. However, Pascual has been reiterated
Yes.
as late
And in
as
Pascual,
2009.
there was an additional reason why the court decided that way. Because the penalty, administrative penalty of dismissal for an elective official attaches only to his term. After his term, you cannot penalize him anymore, correct?
Yes, Your Honor.
So, an elective public official has a term of 3 years. After his term is over, can you still charge him administratively for a misconduct during his term of office?
Not anymore, Your Honors.
Not anymore. Supposing there is a pending administrative case while he was in office, but it was decided after his term, after he left office, can you still impose the penalty of dismissal?
Not anymore, Your
Not
Honor.
anymore.
He's no longer in government
So the-
service.
Penalty for administrative cases attaches to the term, correct?
Yes, Your Honor.
That is the meaning of that case in 1959. There were two reasons, but the primary reason was his term is over. You cannot penalize him for an offense committed during his term in an administrative case. Okay? So the issue now is, can this court say that the people of Makati, we are granting you the power to pardon? Can we do that?
Well, this court has, Your Honor.
Yes, we have, and
Yes,
probably
Your
we should
Honor.
revisit it, correct? Because the power to pardon in administrative cases is a constitutional power of the president which we cannot usurp, correct?
Yes, Your Honor. However, as I mentioned, Your Honor, the
So it's a good
occasion-
ground to revisit that doctrine.
Well, Your Honor, the Supreme Court may revisit. This is, after all, judicial policy only, Your Honor. There is no legislation.
Yes, there is no legislation here, and At the time that the court adopted that ruling, we had a different constitution. In 1987 constitution, we are very strict. Public officials shall be accountable at all times, quote and unquote.
Yes,
that
Your
means
Honor.
even after your term.
Yes, Your Honor. In fact, however, the Supreme Court in 2009, during the effectivity of the present Constitution, still adopted the Pascual
Yes,
ruling, Your
because
Honor.
it was not raised, and it's being raised now squarely, we should probably revisit it. Thank you, counsel.
Thank you.
I would like to ask some questions on the power to suspend.
I'm
It's
sorry,
still
Your-
with you?
Yes, Your Honor.
Okay.
With your indulgence,
In
Your Honor.
Ledesma versus Court of Appeals and in several other cases, this court said that the power of the Ombudsman to remove or suspend under Section 13, Paragraph 3 of Article 11 of the Constitution is a constitutional power that is mandatory. It is not recommendatory only, correct?
Yes, Your Honor.
Okay, so it's a constitutional power. Can the Supreme Court restrain or reverse the Ombudsman in the exercise of his constitutional power to remove or to suspend?
Your Honor, with due respect, Your Honor, the suspension that is contemplated is the suspension as a penalty, not preventive suspension, Your Honor.
So you mean to say that the power of the Ombudsman to suspend or remove under Section 13, Paragraph 3 refers only to the penalty, not to preventive suspension?
No, Your Honor. Under the law, Your Honor, precisely the preventive suspension is a matter that is given to the Ombudsman by virtue of law.
But by virtue of the Constitution, we have already repeatedly ruled that the Ombudsman has the constitutional power to remove or suspend mandatorily, not just a mere recommendation. You agree?
Yes, Your Honor. However,
Okay.
it is our considered opinion, Your Honor, and it is our submission, Your Honor, that the suspension refers to a suspension that is a penalty, meaning that the issues have been
But in all
resolved.
those cases where we said that the power of the Ombudsman to suspend is constitutional, it involved preventive suspension.
Yes, Your Honor. However, there is also a view that preventive suspension,
What view is that? Is that a ruling of the court?
there is a dissenting opinion, Your Honor.
Dissenting. Okay.
Preventive suspension frustrates the will of the people, Your
Yes,
Honor.
but that is dissent.
Yes,
Okay,
Your Honor.
we're talking of the doctrine of the court. The dissent does not establish a doctrine, correct?
Yes, Your Honor. However,
Okay.
it is our submission that the precise purpose
It's your
of a
submission
dissent.
now to convince us that we should follow the dissent. Reverse ourselves. That's what you're saying.
Well, Your Honor, this is the case of Aldovino versus Comelec,
Yes,
Your Honor.
okay, let's proceed. So my question is, can the Supreme Court restrain or reverse the Ombudsman in the exercise of his power to remove or suspend?
Not, the Supreme Court, Your Honor, may not reverse, Your Honor. However, again, we are
Don't we have
referring.
the power of judicial review if agency of the government acts without jurisdiction, if it acts contrary to the Constitution?
Yes, Your Honor.
So we have that power because that is in the Constitution.
Yes, Your
Power
Honor.
of judicial review plus the expanded power of the Supreme Court
We agree, Your
under
Honor.
the Constitution. Correct?
Yes,
So
Your
we
Honor.
can.
Yes, Your Honor.
Okay. Can Congress pass a law removing the power of the Ombudsman to suspend or to remove government officials?
To remove, Your Honor? Yes, Your Honor.
Can Congress pass a law saying from now on, the Ombudsman has no more power to remove or suspend government officials? Can Congress pass such a law?
No, Your Honor, because...
No, it cannot. That's against
because-
the Constitution, correct?
Yes, Your Honor.
Can Congress by law authorize the Court of Appeals to stop or reverse the Ombudsman from exercising this power to remove or suspend?
It is our submission, Your Honor, that Congress does not have to because it is inherent in the power of the court.
Okay.
Judicial power, after all, Your Honor, rests not only in the Supreme
Who
Court.
decides what is the jurisdiction of the appellate courts and the lower courts?
Jurisdiction,
Who
Your
has
Honor.
the power to apportion, prescribe, and define the jurisdiction of lower courts?
Jurisdiction, Your Honor, is a matter of law, Your Honor. Therefore, Congress.
It is Congress.
Yes, Your Honor.
Okay. So Congress, in this case, said it can say that, like for example, in the case of TROs on national government infrastructure, Congress said lower courts cannot issue TROs on national government infrastructure, correct?
Well, with the consent of the Supreme Court, Your Honor, in that particular law, Your Honor, the legislative history of that law will establish, Your Honor, that it was not.
Did the court give its express consent to that?
Yes, Your Honor, the crafting of that law was with the participation of a representative from the Supreme Court, Your Honor. Specifically, then Court Administrator, Your Honor.
Did the Supreme Court and bank issue its comment, its consent?
Your Honor, prior to the enactment of this
What
law.
is the requirement of the Constitution under Section 30, Article 6 on the Congression, on the legislature, on whether the legislature can increase the jurisdiction of the Supreme Court?
It requires the consent of the court, Your Honor.
When Congress passed the law prohibiting lower courts from issuing TROs, did it increase the appellate jurisdiction of the Supreme Court?
Yes, Your Honor.
Why?
Because what would have been a concurrent jurisdiction for the Court of Appeals and the Supreme Court is now exclusively with the
Okay.
Supreme Court, Your Honor.
The jurisdiction of all courts, from Court of Appeals down, is prescribed, defined, and allocated by the Congress, correct?
Yes, Your Honor.
Let us assume that on day one, when Congress passed the Judiciary Act, they already removed the power to issue TROs on national government projects from lower courts. Is that depriving the Supreme Court of its, is that increasing the appellate jurisdiction of the court without its consent?
Well, no, Your Honor, because at the time of the...
No. But now you're saying if the Congress passes that law now, it will require the consent of the Supreme Court? Why?
Yes, Your
What's
Honor,
the difference?
because jurisdiction has already been established, Your Honor. And the issuance of these writs are now merely procedural,
So
Your
you mean
Honor.
to say that once the Congress has authorized the lower courts to issue TROs, then it cannot remove it anymore without the consent of the Supreme Court? That is the doctrine you're saying.
That is our submission, Your Honor. Precisely, Your Honor. Prior to the enactment of this law on the infrastructure, Your Honor, this
So
court...
the power of the Supreme Court is not plenary. The moment they exercise it, they can lose it. That's what you're saying.
No, Your Honor, because in that particular law, Your Honor, the Supreme Court, prior to the enactment of the law, already issued a directive specifically directing that no writs of injunction shall issue against government contracts, Your Honor.
Pursuant to the PD, the court issued that, quoting the presidential decree prohibiting TROs on national government projects. It just quoted it.
Yes, Your Honor. In which case, when this law was enacted, it is presumed that the consent of the Supreme Court is given
If
at the same
Congress
time
now-
with the participation of then court administrator in the crafting, Your
If
Honor.
Congress now passes a law authorizing the lower courts to issue TROs against national government projects, does it require consent of the Supreme Court?
Well, it is a matter of procedure, yes, Your Honor. This is now going into...
To stop national government projects. Is that procedural or substantive?
It is procedural, we submit, Your Honor.
Procedural.
Yes, Your Honor.
So giving the CA the power to stop the Ombudsman from issuing TRO is procedural or substantive?
It is also procedural, Your Honor, hence within the exclusive jurisdiction of this court, Your Honor.
When Congress issued that law saying that TROs cannot be issued against the Ombudsman, if that were procedural, then that is unconstitutional because procedural is supposed to be lodged now in the Supreme Court, correct?
Your Honor, precisely why it is our submission that that law does not prohibit the issuance of a TRO by the Court of Appeals, Your Honor.
So you are saying that that law of Congress prohibiting the Court of Appeals from issuing an injunction against the Ombudsman is unconstitutional. That's what you're saying.
No, Your Honor, what we are saying is that the law does not prohibit the Court of Appeals.
But it says there, no injunction shall be issued.
Yes, Your Honor. However, the requirement for this injunction is that it shall be dilatory under the theory proposed by the petitioner, Your Honor, every injunction is dilatory, for which reason it cannot be reconciled that there is no court.
So you are saying if it is dilatory, then the CA cannot issue the injunction. That's your position now.
Well, our position, Your Honor, is that there is no prohibition. Once the issue of the injunction, the prohibition only matters if the TRO or the writ of injunction is dilatory, Your Honor.
So if it is not dilatory, then the CA can issue it.
Yes, that is our submission, Your Honor.
Okay. So, but can issue it only if there is prima facie evidence that the Ombudsman has no jurisdiction over the subject matter of the case, correct?
No, Your Honor, our submission is that this prima facie is a different clause, and that this modifies that even if it were dilatory, if there is prima facie evidence that it is beyond the jurisdiction of the Court of Appeal, the Ombudsman, then that is the only time that
So
the
you are saying
injunction may be
the
issued.
CA can issue an injunction under two conditions. The CA cannot issue an injunction under two conditions.
Yes, Your Honor.
If it is dilatory and it is outside the jurisdiction of the Ombudsman. That's what you're saying. Those are the two conditions.
The CA cannot issue, Your
Yes.
Honor? The CA may issue if it is not dilatory, Your Honor, yes.
The CA may issue the injunction if
It is not dilatory.
it's not dilatory. And what about the jurisdiction?
Even if it were dilatory, if the Ombudsman acted outside of its jurisdiction, then
Yeah,
that
if
is
the
still...
Ombudsman acts without jurisdiction, then of course it will be void, correct?
Yes,
it will
Your
be
Honor.
arbitrary, it will be subject to the certiorari power.
Precisely, Your Honor.
Okay. So if the subject matter of the investigation is within the jurisdiction of the Ombudsman, now my question is the subject matter of the investigation against Mayor Binay Jr. within the jurisdiction of the Ombudsman?
Yes, Your Honor.
It is within.
Yes, Your Honor.
So the CA can issue the injunction because it is not dilatory,
Yes, Your Honor.
even if it is within the jurisdiction of the Ombudsman. That's what you're saying.
Yes, because in this case, Your Honor, the finding of fact of the Court of Appeals is that the Ombudsman acted with grave abuse of discretion and therefore outside its jurisdiction, Your Honor.
So, in other words, you're saying that the Court of Appeals can stop the constitutional power of the Ombudsman to remove or suspend if it will not be dilatory. That's what you're saying. Because the power to suspend is a constitutional power of the Ombudsman, correct?
Well, that is the ruling of this Court, Your Honor.
So, but you are saying that still the CA can stop the Ombudsman if it will not be dilatory. That's what you're saying.
That is what the law says, Your Honor. That is what we submit.
That is what you believe the law says, correct?
Yes, Your Honor. That is our position, Your
So,
Honor.
in other words, you're saying that Congress can limit the power of the Ombudsman to suspend or remove government officials by authorizing a third party, the Court of Appeals, to do it because Congress itself cannot do it. That's what you're saying.
Well, no, Your Honor. The restriction is what is provided by Congress because inherent in the power of the courts is the issuance of ancillary writs, including a writ of injunction, Your Honor.
Inherent if the court is given general jurisdiction. But it is Congress that decides whether to give special jurisdiction, limited jurisdiction, or general jurisdiction. The RTCs are given general jurisdiction. That's why they can entertain petitions to declare a law unconstitutional. It's a general jurisdiction, but nobody can go to the Labor Department or to the NRC to file that petition. Yeah, they do not have that jurisdiction, correct?
Yes, Your Honor.
So it depends on what kind of authority Congress will give.
Well,
Now, in this case, Congress said, CA, you cannot issue TRO against the Ombudsman. Valid or not valid?
Well, Your Honor, our submission precisely is that that is not what the law says. Clear from the words of the law, Your Honor, we submit, is that there is no prohibition because the prohibition is actually an exception if the injunction is to delay, Your Honor.
So, in other words, even with that law, the CA can stop the constitutional power of the Ombudsman to remove or suspend. That's what you're saying.
Well, as I
So
had-
the law will prevail over the constitutional power of the Ombudsman.
Well, Your Honor, as I had clarified, our position, Your Honor, is that the constitutional power to suspend is the penalty of suspension and not
You are
preventive
saying
suspension.
penalty.
Yes, Your Honor.
Although in all the cases where we said that the power of the Ombudsman to suspend is a constitutional power, it involved preventive suspension. But you are saying, no, it will not cover preventive suspension. That's what you're saying.
Yes, Your Honor.
Okay, so you're twisting our decisions. Okay, can you go to Annex D of the complaint of the Ombudsman? Just the first page of Annex D.
Yes, Your Honor. Yes, Your Honor.
Okay. On the right side, right corner, there is this printed docket number CC 150059. Do you see that? Across. Marginal on the right margin. Annex D of the complaint of the Ombudsman. Annex D of the petition of the Ombudsman. It is the complaint filed with the special panel of investigators.
Yes, Your Honor. The docket number for the administrative case, Your Honor.
No, there is a docket number. One says, okay, the small writing, the first line, it says OMB-C-A-IS-0058. Do you see that?
Yes, Your Honor.
What does OMB-C-A? What does C and A stand for?
The A is for that. This is the administrative
This
complaint,
is the
Your Honor.
administrative case.
Yes, Your Honor.
Okay, the next number is OMB-C-C-IS-0060. What do these letter C stand for?
This would mean that this is the criminal case, Your Honor.
Okay, so this docketing refers to both the criminal and the administrative aspects, correct?
Yes, Your Honor.
In one complaint, correct?
Yes, Your Honor. We
Okay,
confirm
that is all, counsel. Thank you.
Thank you very much, Your Honor.
Si Justice Leonen? O Justice Perez?
You went to the Court of Appeals on your submission that the Ombudsman committed grave abuse of discretion in the issuance of the PSO, correct?
Yes, Your Honor.
And from the statement of Pañero Certeza a while ago, that grave abuse of discretion consists in issuing the PSO even before a comment could be filed. My question is, would you know at what stage the investigation in the administrative case is right now?
Your Honor, the respondent in the administrative case, Your Honor, filed his counter affidavit already, which refers to both the criminal and the administrative case, Your Honor. This was on March 30, 2015, Your Honor.
Okay. And on the basis of that counter affidavit, the Ombudsman says now that there is reason for the issuance of a PSO. Again, I mean a reissuance, no, not a reissuance, but an issuance of another PSO on the basis of what is extant in the records before the Ombudsman. Can the Ombudsman do that?
we will have to disagree with the position of the Ombudsman, Your Honor, because the Ombudsman does not have the power based on law to issue 2 preventive suspensions, Your Honor.
And what makes you say so?
Your Honor, the discussion on preventive suspension, Your Honor, in the law, Your Honor, refers to, while the first sentence refers to sorry, Your Honor.
So it's your position, counsel, that at this point, the Ombudsman does not have any authority anymore to issue a preventive suspension order. If the Ombudsman, for example, withdraws its petition before the Supreme Court, and after withdrawing it, thus rendering the discussions here moot and academic, insofar as the first PSO is concerned, and then on the basis, as I said, of what is extant in the records of the Ombudsman, issues a preventive suspension order. Are you saying that that cannot be done by the Ombudsman?
Yes, Your Honor. The preventive suspension, Your Honor, is a power that is part of the administrative investigation of the Ombudsman and not in the criminal investigation, Your Honor.
I'm not talking about the criminal investigation. I'm talking about the administrative investigation. As I mentioned a while ago, I was asking you, at what stage is the administrative investigation right now? And you said that the respondent, John Binay has already submitted this counter affidavit, etc., etc. On the basis of these submissions of John Binay, cannot the Ombudsman at this point or at that point issue a PSO on the basis not of the records or of the reasons that are already the subject of the present controversy, but on the basis of what is newly presented before her?
It is our submission, Your Honor, that the Ombudsman may not issue a second preventive suspension anymore, Your Honor. The purpose of the preventive suspension, Your Honor, is clear. It is for the purpose of allowing the Ombudsman the opportunity to investigate the respondent. However, Your Honor, it has been shown that the purpose for the preventive suspension has already been served, Your Honor. Therefore, there can be no second preventive suspension, even as we will not concede, Your Honor, that the Ombudsman can repeatedly issue preventive suspensions, Your Honor.
I am not saying repeated suspensions. I am saying that the first suspension order you said was defective because it deprived due process, or it was a deprivation of due process in the part of John Binay. But cannot that be corrected in the process of the continuance of the administrative investigation?
We would like to clarify, Your Honor, our position that the grave abuse of discretion in the issuance of the preventive suspension is not based on the fact that it was issued prior to the solicitation of the counter affidavit. But it is the fact that there is no strong evidence, Your Honor, as established by law, Your Honor.
What if the Ombudsman now says that because of all these evidences that has been submitted after the first PSO, there is now evidence, the evidence of guilt is now strong?
Well, Your Honor, that matter now is before the Court of Appeals we submit, because the issue of the propriety of the preventive suspension by jurisprudence is an issue of fact, Your Honor, which should be determined in the Court of Appeals, Your Honor. So if the Ombudsman will revisit her position, then it will have to be after the Court of Appeals shall have ruled on whether or not there is strong evidence to support the
Does not a
preventive
withdrawal of the
suspension.
petition by the Ombudsman before the court render useless what is pending before the Court of Appeals?
We submit not, Your Honor, because the issue before the Court of Appeals, Your Honor, is precisely the grave abuse of discretion of the Ombudsman, Your Honor.
Okay. Thank you, Counsel. May I go to one more point, Chief? This is as regards condonation. This is a hotly debated issue, whether or not it's applicable or not. At the very least, there is doubt whether or not condonation is applicable to this case. Does not that doubt affect that requirement evidence of guilt is strong?
Your Honor, our submission is that there is no doubt of the applicability of the Pascual ruling, Your Honor. In the first place, Your Honor, there can be no grave abuse of discretion on the part of the Court of Appeals in adopting and merely complying with what is extant jurisprudence. Your Honor, this Pascual doctrine of condonation is good law. It has yet to be revisited by this court, and for that reason, Your Honor, there is no basis for a disagreement with this law. As I have asserted earlier, Your Honor, while this court is empowered to revisit judicial doctrine, Your Honor, it will have to await a proper case filed before
And at the very
court.
least, you're saying that at this point, considering the existence or the standing jurisprudence on condonation, there can be no strong evidence of guilt to justify the issuance of a PSO.
That is
Thank
our
you.
submission, Your Honor.
Thank you, Madam Counsel.
Justice De Castro,
Yes, Your Honor. Good afternoon.
just very few questions. It's
Good
about
afternoon, Your
preventive suspension, and this will follow the line of reasoning, questioning of Justice Perez.
Yes, Your Honor.
Now, how do you characterize the power to issue preventive suspension order? Is that an inherent power of the Office of the Ombudsman, or is it a power granted by law, just by law?
It is a statutory power. It is
Statutory.
granted under the Ombudsman Act, Your Honor.
Since you said this is a statutory power, are there conditions laid down by law for the exercise of this power? to
Yes, Your
preventively
Honor.
Suspend?
Yes,
Okay.
Your Honor. The preventive suspension is discussed under Section 24 of the Ombudsman Act, which will require, first, that evidence of guilt is strong, and any of the following: that the charge against such officer or employee involves dishonesty, oppression, or grave misconduct or neglect in the performance of duty, or the charges would warrant removal from the service, or the respondent's continued stay in the office may prejudice the case filed against him, Your Honor.
In your petition before the Court of Appeals, did you question the existence of all of these conditions laid down by law for the Ombudsman to issue a preventive suspension order?
Yes, Your Honor, specifically that evidence of guilt is strong.
What is this issue? Is this factual or legal?
Yes, Your Honor, under the ruling of this court in Kapulong, Your Honor, this is a factual issue which the Court of Appeals rightly ruled upon, Your Honor, in a Rule 65 petition.
How letter A and letter A and letter C, will this involve factual issues to be determined by the Court of Appeals?
Yes, Your Honor, the ruling in Kapulong does not distinguish which of the requirements form part of the determination. The ruling of this court is that the determination of the propriety and legal basis for the preventive suspension is factual, Your Honor, for which reason the Court of Appeals rightly ruled in the certiorari petition, Your Honor.
What about letter B? Is this legal or factual?
This is factual, Your Honor, again.
The charges would warrant removal from the service?
Yes,
You
Your Honor,
consider
this
that
is...
still factual, or is it mixed factual and legal?
Well, Your Honor, the penalty is provided by law.
Questioning the validity of the preventive suspension order before the Court of Appeals because of the absence of the requisites laid down by law?
Yes, Your Honor,
And
please.
most of these are factual issues.
Yes, Your Honor,
And
please.
do you think this court can evaluate these factual issues?
Precisely, Your Honor, that is our submission, that consistent with the ruling of this court in Garcia, this court will have to defer to the findings of fact to be made by the lower court, specifically the Court of Appeals, Your Honor, because this court is not a trier of facts, Your Honor.
So you're saying that until after the Court of Appeals has decided your petition before the petition you filed before the Court of Appeals, this court cannot pass upon the validity of the issuance of the preventive suspension order?
That is our submission, Your Honor, the same being a factual issue, Your Honor. Thank you very much, Your Honor.
Justice De Castro, Justice Del Castillo.
Just a few follow-up questions on continuation, counsel.
Yes, Your Honor.
You mentioned earlier about the possibility of abandoning this legal concept of condonation, considering that this just came about because of case law, of jurisprudence, and it's not based on any statute.
Yes, Your Honor.
What possible grounds could be considered for us to revisit this concept and abandon it?
Well, Your Honor, at the minimum, Your Honor, this will have to be litigated in an appeal, Your Honor, where precisely the determination of error of judgment may be raised in a Rule 45, Your Honor. Precisely our submission that even as the court may have the power to revisit, it will have to await a Rule 45, Your Honor, precisely on the question of error of judgment, Your Honor.
Would the amount of the misdeed or the gravity of the offense be one of those grounds that could possibly lead this court to abandon this concept?
I would not wish to speculate, Your Honor. However, this court will, in the meantime, have to rely on the fact that the criminal action remains despite the condonation doctrine, Your Honor. After all, the condonation only applies to the administrative aspect. So it is not as
Yes, but as you know, criminal proceeding is a bit tedious. It takes long.
Yes, Your Honor. However,
I'm just saying this because, as you mentioned about Pascual, 1959 case, so this concept has really been evolving. Pascual,
Your Honor.
it had something to do with the usurpation of judicial authority.
Yes, Your Honor.
So, and then you have Lizares and what's the other one about involving asphalting contract.
Yes, Your Honor.
Now you'll see that the disparity between that and a building contract of a city hall, no? So you can see, no? So I'm just, would you say that in the future there's a possibility that perhaps this doctrine could be abandoned?
yes, Your Honor, that is a possibility, precisely because this is judicial doctrine only. The court may revisit whether the court ultimately will uphold or reverse itself, Your Honor, is entirely within the discretion of the Honorable Supreme Court, Your Honor.
Justice Bersamin, Justice Villarama.
Call on Attorney Certeza.
Good afternoon, Your
Good
Honor.
afternoon, Attorney Certeza. Just a few questions. Do you agree that upon the filing of the administrative complaint against Mayor Binay Jr., the provisions of RA 6770 or the Ombudsman Act will now apply?
Yes, Your Honor.
So when he was served with the petitioner's ombudsman joint order for the DILG to implement the preventive suspension of respondent Mayor Binay Jr., any court injunction to delay the ombudsman investigation proper is now prohibited under Section 14.
We do not agree to that, Your Honor, please. For the reason that while we recognize the existence of Section 14, there is also Article 8, Section 1 of the Constitution, Your Honor, please. And it is our humble submission that this law is supreme, that if there is abuse of discretion in the issuance of the joint order, it can be made the proper subject of a certiorari case before the Court of Appeals.
Just a follow-up, Attorney. But since the petitioner ombudsman seeks a clarification on the extent of the court's jurisdiction to interfere in its preventive suspension orders, as in this case, isn't it that the exception you are invoking under the doctrine of condonation is a pure question of law, which he has properly brought to this court in a certiorari petition under the second paragraph of Section 14 with application for injunctive remedy?
Your Honor, it is our humble position that as regards the validity of the temporary restraining order, it involves factual issues. and even the issuance of the writ of preliminary injunction, they involve resolution of factual issues, Your Honor.
Are you saying that we do not have the inherent power to relax the strict procedural matters in order to address issues of paramount public interest? Because the public respondent Court of Appeals justified its TRO by citing, quote, possible repercussions on the electorate who will unquestionably be affected by the suspension of Respondent Binay Jr. So do you agree that Petitioner Ombudsman raised before this court an issue of paramount public interest which this court should now resolve?
Whether or not the issues before this honorable court involves paramount interest, I will agree to that in a sense, Your Honor, that the will of the electorate is affected one way or the other, Your Honor, please.
Okay. The basis of the Ombudsman power to impose preventive suspension is Section 24 of 6770.
Yes, Your Honor.
Correct? The 6 months maximum period is longer than the 60-day preventive suspension period provided in the local government code.
Yes, Your Honor.
What do you think is the purpose for the shorter period provided for in the local government code?
If my memory serves me correctly, in one article I came across, Your Honor, please, there was made mention that because the local government code involves the application of the suspension by the Secretary of Interior or Secretary of Interior and Local Government, there was a fear that there will be politics involved.
Correct, correct. Let me go to another question. Respondent Mayor Binay Jr. moved to cite for contempt the Honorable Ombudsman for alleged willful disobedience to the CHTRO, correct?
Yes, Your Honor.
What about the refusal of Respondent Mayor Binay Jr. to accept his suspension order and recognize the Vice Mayor who was already sworn in as acting mayor? Is that not contemptuous also?
Your Honor, it is our humble submission that those are two separate, entirely separate matters. With respect to the Ombudsman, in relation to the petition to cite the Office of the Ombudsman for contempt, the allegation was there was a deliberate refusal to comply as indicated by the manifestation filed before the Court of Appeals, where instead of the Ombudsman moving for a reconsideration of the temporary restraining order, it was manifested that they will not comply because it is their submission that it is moot and academic. To our mind, Your Honor, this is contemptuous. Now, I go to the refusal or the refusal of the Mayor Binay. In that particular case, Your Honors, Mayor Binay did not vacate his post because he was acting on the belief that there was still a petition filed with the CA, and he was asking that before he will be complying with any order of the Ombudsman, that his petition before the Court of Appeals is allowed. The difference here, Your Honors, is the fact that in the case of Mayor Binay, he resorted to the courts for relief, and he agreed to be bound by the decision of the courts, Your Honors.
Yeah, but the preventive suspension came hours ahead of the injunction issued by the CA. Is this not also disobedience to the lawful order of the
Your
Ombudsman
Honors,
being implemented by the DILG?
Your Honor, please. It is our submission that when Respondent Binay filed a petition before the Honorable Court of Appeals, and he asked for the issuance of a TRO, he was seeking to preserve the status quo before the controversy. And it is our humble submission, as backed up by case law, that the status quo being referred to is the status quo of the parties at the time of the filing, where he was still the mayor, Your Honor. In other words, Your Honor, we are arguing on a point of law and jurisprudence that he was never removed. So there was nothing to defy, Your Honor.
Is it correct to say that when Respondent Mayor Binay Jr. disobeyed the Ombudsman order, it was in anticipation of the issuance of a TRO by the CA on that same day?
Your Honor, I would not go to the extent of saying that he disobeyed the Court of Appeals. And we believe that this is the correct procedure, because then everybody would await the decision of the court before they act on their own.
Last question, Attorney.
Yes, Your Honor.
During the hearings conducted by the Senate Blue Ribbon Committee, in connection with the alleged anomalous contract for the construction of this parking building too, it is now public knowledge that Respondent Mayor Binay, after attending one or two hearings, later refused to appear before the Senate. Is that correct?
Yes, Your Honor.
Isn't it that the reason given was the supposed bias and prejudgment by some senators against him?
Yes, Your Honor. If I may add also one thing, if I'll be allowed, Your Honor. Also, the fact that there was a repeated request on the part of Respondent Mayor Binay for him to be advised of the topics of the future hearings, and if at all possible, that he will be informed of the areas where he will be questioned. And these are backed up by several letters to the Senate, and none of these requests were acted upon.
Okay. Given the testimonial and documentary evidence presented during the Senate hearings and the reaction of Respondent Mayor Binay Jr., do you think Petitioner Ombudsman was correct in concluding that preventive suspension is necessary for her office to effectively conduct their own investigation?
Your Honor, I disagree, and I will state my reasons. First and foremost, Your Honors, if Your Honors will recall during the last hearing, the Honorable Ombudsman was here, and she said that it was necessary to preventively suspend the Respondent Mayor because there is a need for them to gather more evidences with regards to the plunder case. We would like to point out, Your Honors, that the case before this Honorable Court is not the plunder case, but merely an administrative case concerning overpricing. In other words, Your Honor, what the Ombudsman is trying to do is to use preventive suspension in this case to gather evidence for another case. And we're saying this should not be allowed. Also, Your Honors, during the investigation in the Senate, we believe that it should not be a proper, whatever is the investigation conducted before the Senate, should not be the proper consideration for the Ombudsman to decide whether to preventively suspend or not. Because the Senate is an entirely new territory where there are no rules of procedures like before this Honorable Court.
What again is the purpose of a preventive suspension, Counsel, in general?
The purpose of the preventive suspension? Your Honor, we always go back to our firm position that the law says that before one can be preventively suspended, if he is a public official, the evidence of guilt is strong. And we are strongly submitting that no such evidence exists.
Okay. Last point, Counsel. On a personal note, in an informal gathering, I was told, and this is not hearsay, from a lawyer from the Ombudsman. She's not my wife, though. She has resigned last September 1. That the City Hall officials have been ignoring subpoena duces tecum issued to them by the Ombudsman. Will you please comment on this?
If I may respond, Your Honor.
Please.
Your Honor, every time the officials of Makati will be served with subpoena or notices, what we do is we write the Senate and reply and respectfully request what is it that is the topic, what it is that is going to be asked, what will be the subject, Your Honor, please. Which are, to my mind, are reasonable requests.
I'm asking subpoena duces tecum issued by the Ombudsman, not
With
the
respect,
Senate.
Your Honor, I stand corrected. With respect to subpoena duces tecum, I have a list here, Your Honor,
List of what?
of documents that were submitted. In other words,
Just
Your
answer
Honor,
my question or clarify. You're saying that you have not ignored the City Hall official responded.
we don't ignore the subpoena duces tecum, Your Honor.
So what I heard, the lawyer told me is not correct.
It is not true, Your Honor. And
Thank
we
you
can
very
prove
much.
it.
Thank you for cooperating with the investigation process.
Thank you, Your Honor.
Justice Reyes.
Good afternoon, Mr. Counsel.
Good
Actually,
afternoon, Justice.
These are not, these are mere confirmatory questions designed to guide me in order to have a complete knowledge relative to the facts and issues involving this case, conformably, of course, with the present Constitution, the jurisprudence and doctrines. Will you confirm that although the Office of the Ombudsman has a constitutionally guaranteed independence and autonomy, it is not exempted from the expanded power of judicial review under Section 1, Article 8 of the 1987 Constitution?
I agree in part insofar as the reference of Mr. Justice is concerned as to Article 8, Section 1 being supreme, but it is my humble presentation that that refers to judicial powers, the exercise of judicial powers.
All right. Hence, would you agree with me and would you confirm that that when the Court of Appeals issued when the CA did not commit any grave abuse of discretion in issuing the TRO against the Ombudsman's order? Can you appeal
Yes, I confirm, Your Honor.
that? Notwithstanding the enactment of Republic Act 6770, more particularly the Ombudsman Act, the Ombudsman remains subject to the expanded power of judicial review.
Yes, Your Honor, I confirm that.
That this conclusion is bolstered by the fact that the court in several cases had upheld the power of the courts to issue a TRO against the decisions of the Ombudsman.
I confirm that. Yes, Your Honor.
All right. That the TRO issued by the CA did not violate in any way Section 14 of Republic Act 6770.
I confirm, if I may be allowed to add, Your Honor, it is always our submission that Section 14 should be construed, interpreted, always with due deference to Article 8, Section 1.
That is in relation with that. Section 14 only prescribe the issuance of writs of injunction which delayed the Ombudsman's investigation.
Yes,
You're referring
yes, Your
to that,
Honor.
ano? And that the TRO issued by the Court of Appeals merely enjoined the preventive suspension order and not in the conduct of the investigation proper.
Yes, Your Honor.
Referring back to specific facts or matters, the contract with the Mana Architecture and Interior Design Company vis-a-vis the Makati City Hall Parking Building project was entered into by the City of Makati on November 28, 2007, when Binay was not yet the mayor of Makati City. Can you confirm that?
I confirm that. And Mr. Justice, if I may be allowed, if there are other questions about Mana, it will be Attorney Coronel if you will have other questions.
Or, based on my understanding regarding the issue
Yes, Your Honor.
that the contract with Hillmarks for phases 3 to 4 Makati City Hall Parking Building Project was entered into by the City of Makati during the first term of Binay as mayor from June 2010 to May 13, 2013.
Yes, Your Honor. Phases 3 to 5 all occurred during the first term.
And that pursuant to the case, but more particularly the case of Aguinaldo versus Santos, a public official cannot be removed for administrative misconduct committed during a prior term,
Yes, Your Honor.
since his re-election to office operates as a condonation of the officer's previous misconduct.
Yes, Your Honor.
Now, that pursuant to the case also which you cited in one of your pleadings, Garcia versus Moica, the doctrine of condonation still applies even if a total of 3 payments were made to Mana and Hillmarks during Binay's present term. Can you confirm
Yes,
that?
Your Honor. Following the ruling, I think that was the case of Salalima, Your Honor, and Mojica.
All right, last few questions, Mr. Counsel. It is a basic that injunction would not lie where the acts sought to be enjoined have already become fait accompli or an accomplice or consummated. Do you agree with me?
Yes, Your Honor.
Do you likewise agree with me that the issuance of a writ of preliminary injunction and or temporary restraining order, notwithstanding that the act sought to be enjoined had already become fait accompli, constitute grave abuse of discretion amounting to lack or in excess of jurisdictions?
If the facts clearly show that the issues have been rendered moot and academic already, I agree, Your Honor.
Will you confirm with me, Mr. Counsel, that on March 11, 2015, the Office of the Ombudsman personally delivered a copy of the preventive suspension order at the office of the city mayor, which was received by a certain Maricon Acusan. Can you confirm?
May I be allowed just to consult my records?
All right,
Because
Your
just to be exact about the date. Yes, we agree it was served March 11 at the office.
Then had already been implemented, would you agree with me that the Court of Appeals gravely abused its discretion in issuing the March 10, 2015 joint order, since the act sought to be restrained had then become fait accompli? Do you agree with me?
We disagree, Your Honor. And if we were allowed to give our reasons. Your Honor, please, as regards jurisprudence on writs of preliminary injunction and TROs, Your Honor, the consistent ruling is that these are auxiliary remedies to preserve the status quo. And there are jurisprudence to the effect that status quo is defined as the last peaceful, actual, uncontested situation of the parties prior to the controversy. In this particular case, Your Honor, the controversy is the suspension of respondent mayor. That is the controversy. So we reckon the status quo being made prior to that, which is when the case was filed. And for that reason, Your Honor, it is our humble submission that that status quo here, in this case, was the condition of the parties then that respondent mayor was still the mayor of Makati, and the preventive the joint order coming from the Ombudsman will not automatically render him not the mayor anymore. So the Court of Appeals have every right to issue the TRO to stop. And I stress it is temporarily only, because the case will still have to be decided before the Court of Appeals, to stop the implementation of the order, which we believe, Your Honors, is not really unreasonable. Because, as I earlier mentioned, preventively suspending an elective official is entirely separate and distinct from the conduct of an investigation. And the investigation is ongoing even until now. And the parties, the respondents, including the respondent herein, they have been continuously submitting counter affidavits and documents in order to give light to the Ombudsman on how it will finally make a determination under their investigation. Thank you, Your Honor.
The doctrine of condonation, particularly initiated in the Aguinaldo case, applied to all cases, meaning to say in both administrative and criminal cases.
It applies only to administrative cases, Your Honor, by virtue of case law.
All right, thank you very much, Mr. Counsel.
Thank you, Your Honor.
Justice Bersamin, then Justice Leonen, just one question from Justice De Castro, then Justice Leonen.
Thank you, Madam Chief Justice. Good afternoon, Attorney Certeza.
Good afternoon, Your Honor.
The party who went to the Court of Appeals was your client.
Yes, Your Honor.
What mode did he use?
Rule 65, Your Honor.
Rule 65, and it was his claim there specifically that the Ombudsman committed grave abuse of discretion in issuing the preventive suspension order.
Yes, Your Honor.
And the grave abuse of discretion consisted in what?
In the fact, Your Honor, that it was very evident on the records, the timeline where the pertinent incidents happened. It is very evident there that following the tier of condonation, he should not be made administratively liable anymore. That is one ground. The other ground is, again, based on timeline, which can be shown on record. It took the Ombudsman several days only to come up with the joint order authorizing the filing of the case against my client, when what had to be reviewed was voluminous documents that was presented.
Okay.
So in all, that was our presentation, that there is grave abuse of discretion, Your Honor.
Okay, you were here last week.
Yes, Your Honor.
When the Ombudsman herself was present, and she was asked how long should it take her to issue a preventive suspension order in the course of an administrative investigation. And I don't know if we agree about hearing the same thing, but what I heard was this: she could issue it at any time after the commencement of the investigation. Was that also what you heard?
What I heard, Your Honor, is that there was even mentioned that she could do it in 1 day.
I'm not talking about how much time you need to do it. How much time after the filing of the administrative complaint or commencement of the administrative investigation should you give under a law that you know exists the ombudsman to issue the preventive suspension order if she wanted to? Because this is about discretion.
Yes, Your Honor, I agree. So I think I heard the same thing that His Honor mentioned.
She did not say 1 day. She did not say 3 days. And I think I heard her say at any time, at any time. It could be 1 minute, 1 second.
Yes, I recall that now, Your Honor.
All right. Now you were stating that the records were voluminous, and because of the volume of the records, you would presume that she could not have had any basis, factual or otherwise, to issue a preventive suspension order, because you are presuming that she was a slow reader.
With due respect, Your Honor, I am not assuming that Ombudsman.
Hey, that's
is
what
a
it
slow-
implied.
No, Your Honor, it's only that this is a construction project, Your Honors, if I may say, that spanned, I think, close to 4 or 5 years. And it was done in stages. And even when we were in the Senate, Your Honor, regarding the documents that were being requested, it's really voluminous, Your Honor. And
Alright.
I believe that a few days would not give a person a chance to make a very astute decision.
Well, we have different levels of intelligence, but as far as I am concerned, I have worked with the Ombudsman on a personal, direct level. She was my chairman in the 3rd Division for a long time, and I could tell you and all the rest of the public today that she was a fast reader and a fast worker. But anyway, this is the point. That is a presumption that I see in your statements, because you could not believe that she could not have perused the records. That's the point that you are raising.
Yes, it being voluminous.
Is
Your Honor.
that grave abuse of discretion?
That in isolation is not. I admit that, Your
In
Honor.
isolation.
Yes, Your Honor. There are other matters that we have considered for us to submit that there was grave abuse of discretion.
Okay, we have no standard in the law or in the Constitution. Whenever that phrase crops up, evidence of guilt is strong. Not in the Constitution, not in the Ombudsman Act. Do you agree to my statement? There is no standard except that word strong.
Your Honor, if I may, I recall having read a case decided by this honorable court where grave abuse of discretion have been likened to an act when one disregards established jurisprudence. That
Well,
can be the basis
don't
of the
talk about the
conclusion.
condonation yet. I will go to that when the beauty
No.
in your team will answer.
Your Honor, for basis, for asking for a standard, that whether an act is with grave abuse of discretion, what this representation is merely saying is, in one case, the Honorable Supreme Court said, when an instrumentality of government disregards jurisprudence, or a lower court disregards jurisprudence, that is grave abuse of discretion.
Oh, but we have been uniform about this, consistent even before I was born. Grave abuse of discretion is about whim, caprice, and what is the other term?
Wanton disregard.
Arbitrariness.
Arbitrary.
So
With passion and...
come within these three, and I will probably believe you. But,
Yes, sir.
you know, there was one case that I remember right now where the judge was absolved by the Supreme Court of any act of grave abuse of discretion despite the voluminous record that he had. He was expected to read, but he issued a warrant of arrest without probably reading, actually, the records of the case. Do you remember that case that I'm talking about? This was the case of the Masbate murder trial, Lim versus Salazar, or either Felix, Nemesio Felix, Judge Felix, where there was an order to transfer that case from Masbate to Makati, to Makati, yes, where Judge Felix was presiding. And Judge Felix, as soon as the records there, as soon as the case was assigned to him, issued a warrant of arrest. I was wrong about it. Salazar, the case of Judge Salazar, comparing it with the Lim versus Felix case. In Lim versus Felix, Judge Felix was said to be having acted in grave abuse of discretion because he issued the warrant of arrest without the records of the case having been yet transmitted to him. But in the case of Judge Salazar of Quezon City, the case of rebellion that was filed against Senator Enrile and others consisted of volumes of records. But yet Judge Salazar took only 1.5 hours from the time the case was raffled to him to find probable cause and issue a warrant of arrest. But the Supreme Court said he is presumed to have read everything. So he did not act in grave abuse of discretion. Is that the way you don't see it this way?
No, Your Honor.
Okay. Now, grave abuse of discretion is a relative term depending on the facts and circumstances of its case.
Yes, Your Honor.
All right. Shall you not presume the Ombudsman to have acted in the regular performance of her duties, considering that below her were very many competent legal persons, lawyers, and super lawyers at that?
I will agree that the Ombudsman and the Office of the Ombudsman they have established and competent lawyers, numerous as they are, Your Honor. But let me point out to the Honorable Supreme Court, in the joint order that was given, there were people here who were ordered preventively suspended by the Ombudsman, who were not even employees of the City Hall. That is why, taken all together, our submission is there is something wrong that the joint order was issued in this way. With due respect to the people in the Ombudsman, it would have appeared to be haphazard. And we're saying that can be the basis now for concluding that there is grave abuse of discretion.
Okay, may I now turn to Attorney Coronel?
Yes, Your Honor.
Good afternoon, Your Honor.
All right. Attorney Coronel, may I ask you to take that down?
Yes, Your Honor.
Because decorum here is very strict. Attorney Coronel, the assigned topic to you is condonation.
Yes, Your Honor.
And more or less, you and I know what is the meaning of condonation.
Yes, Your Honor.
If you were to apply this to the case of Mayor Binay, that is a matter of defense. Don't you agree? That is a matter of defense.
Well, Your Honor, this court has ruled that that is a matter that may be taken consideration of by the Court of Appeals, Your Honor.
Yes. But the point that I am trying to drive at is this. The Ombudsman is not expected to consider that from the outset. Because all she is set on doing is to implement the law as far as she saw it. Meaning, preventively suspend the respondent she believes there was sufficient or strong evidence of guilt against.
Yes, Your Honor, but that already presumes that there is a belief before evidence establishes it. Precisely, Your Honor.
Yeah.
That is the basis for our claim that there was grave abuse. When the Ombudsman has as a premise that there is evidence of guilt being strong, and the evidence just comes after that, then precisely it is not, it is putting the cart before the horse, Your Honor.
Okay. Now, the Ombudsman has no obligation to take judicial notice of elections, the results of elections, who are those who are elected, who are those who lost in the elections, especially in a city like Makati, because that is not a national office.
Yes, Your Honor. However, preventive suspension, being a frustration of the will of the electorate, must be exercised with great restraint, Your Honor, taking into consideration the facts of the case, Your Honor.
Okay. So you accuse the Ombudsman in the Court of Appeals of having committed or gravely abused her discretion because she did not consider condonation. Is that your point?
Because the Supreme Court, Your Honor...
No, never
has
mind the
ruled-
Supreme Court. That Supreme Court was not yet involved at that time.
No, Your Honor, invoking the ruling of this court that preventive suspension may not be applied in the case...
Okay, I'll give you another setting. An accused who stands charged with killing somebody, will the court be expected to take cognizance that he acted in self-defense if there was no evidence yet?
No, Your Honor, but that is a criminal case, Your Honor.
Yeah. But I'm just analogizing. Okay.
Yes, Your Honor.
I think we are done with that. But this is the next question. You were insisting a while back that only a Rule 45 appeal could probably revisit the
Yes, Your Honor.
issue of condonation.
That is our submission.
Why do you
yes, Your
believe
Honor.
that?
Your Honor, because the only issue presented before this court, Your Honor, is the assertion of the Ombudsman that the CA committed grave abuse of discretion, Your Honor. The determination of the factual basis for the preventive suspension is a matter of fact, Your Honor, which this court should restrain from making a ruling about, considering, Your Honor, that should this court make a ruling on the facts, specifically the applicability or the propriety of condonation, it will have removed from the Court of Appeals the jurisdiction to make a similar or conflicting determination of fact, Your Honor.
Right. You've been in this case for the longest time, maybe from day one.
Yes, Your Honor.
Even before you went to the Court of Appeals, you were already with Mayor Binay's side?
No, Your Honor.
All right. But since you were assigned this topic of condonation, let me ask you this. When was the first time that the word condonation ever cropped up? Be careful about lawyer-client confidences, but I'm just interested in a timeline.
Well, Your Honor, immediately after being presented with the preventive suspension order, Your Honor, there already was an assessment of the complaint. My understanding, Your Honor, is that the matter of condonation being a defense was immediately brought to the attention of the mayor, Your Honor.
How about to the Ombudsman?
Well, Your Honor, the opportunity to bring that to the attention of the Ombudsman was during the filing of the counter affidavit, Your Honor.
Before I ask the next question, let me just be satisfying my curiosity. Do you agree with Attorney Certeza here when he said that the Ombudsman could issue the preventive suspension order according to what she claimed last week as soon as the administrative case is filed?
Well, Your Honor, precisely the determination of the propriety is a matter for the assessment of the Court of Appeals as a question of fact, Your Honor. We will not want to argue on the speed reading, Your Honor. However, circumstances clearly establish that there is grave abuse of discretion, for which reason we had to resort, Your Honor, to the Court of Appeals. This matter has not yet been established as a matter of fact, precisely, Your Honor, because instead of addressing the issues before the Court of Appeals, the petitioner chose to go straight up to the Supreme Court, Your Honor, not even filing a motion for reconsideration, Your Honor, of either the TRO or the writ of preliminary injunction that was issued, Your Honor.
Okay, let's go back to your thesis. Only a Rule 45 appeal could enable us to review and revisit condonation.
Yes, Your Honor.
You still go along by that belief?
Yes, Your Honor, that
Now,
is...
do you believe that in this particular case that we now have here, which was brought to us by the Ombudsman, the issue of condonation is itself in the center of the controversy?
No, Your Honor. The only issue is grave abuse of discretion on the part of the Court of Appeals, Your Honor. The exercise of the Ombudsman of its prerogative to preventively suspend is before still the Court of Appeals, Your Honor. For this reason, that is not a fact that is yet within the reach of this court, Your Honor.
I will request you to file a memorandum later on regarding your theory that only a Rule 45 appeal could enable the court to revisit.
Yes, Your Honor.
Okay.
We will do that.
Now, the next question that I would like to ask you is this. The condonation theory applies only to a re-electionist. It will not apply if this elected official is charged but subsequently wins election for another position.
That is what the cases say, yes, Your Honor.
What do you believe?
Well, we will have to go by the ruling of this court, Your Honor, that it will require a re-election.
Okay, what do you think is the reason why there is a distinction between a re-electionist and a newly elected official in another position?
In another position, Your Honor?
Halimbawa, si Mayor Binay, mayor nung last term, congressman na siya ngayon, hindi pwede yung condonation. Bakit kung halimbawa, Mayor Binay last term, Mayor Binay pa rin ngayon, applicable? That's the point that I am asking you to address.
Well, Your Honor, this court has not had the opportunity to revisit this particular aspect.
So there is a weakness in the condonation theory.
No, Your Honor, because on all fours is the factual milieu of our client.
But-
He was re-elected
All right.
for the same position,
Do you
Your
remember
Honor.
what Justice Davide said in Salalima?
Yes, Your Honor. May we ask what's particular?
Justice Davide said in Salalima that we have to continue this condonation principle so that we will spare the respondent who is re-elected from political attacks
Yes, Your Honor.
of his opponents, and he will spend his coming term defending himself. We have to stop that practice, he said.
Yes,
Now,
Your
is
Honor.
that not also applicable to a person who is charged when he was in a particular position but is elected to another position in the next elections?
Well, I will not exclude this particular situation, Your Honor, precisely because there is no jurisprudence on the matter, Your Honor, of an election to a different position, Your Honor.
Okay. We are clear about it is irrelevant or immaterial when the administrative case was begun, whether it was in the former term or in the current term. There
Yes,
is
Your
still an application of that doctrine. Is that, you agree with that, of
Yes,
course?
Your Honor.
Okay?
Completely.
So the time element here is irrelevant, and even if, as was the answer to Justice Bernabe a while ago, the condonation theory is applicable to, was it Justice Reyes, to somebody who is charged even if there was already subsequent payment, like in the Mojica case.
Yes, Your Honor. That is the ruling of this court, Your Honor.
So what is there to condone kung tuloy-tuloy ang violation?
No, Your Honor. The ruling of the court is with respect to the payment made during the present term, Your Honor. So the condonation applies to the supposed transaction that happened in the previous term. Your
Yeah.
Honor.
What I cannot understand is this. You would insist on condonation, but the underlying principle for condonation is that the sovereign people have spoken and have forgiven
Yes,
the
Your Honor.
re-electionist of his past sins, even if they did not know
Yes,
these
Your
past sins. Huh?
Yes, Your Honor.
But here is this sinner who continues to sin
Well,
beyond that first term.
Well, that is a matter of fact, Your Honor, that will still have to be established. The question before this court on a purely factual basis will be limited to the factual milieu, Your Honor. In this case, Your Honor, the charge...
Please cover that also in your memorandum. Now, this is the last question.
Yes, Your Honor.
Why did you go to the Court of Appeals on Rule 65? Why did you not come directly to us on Rule 65? It was you who went to the Court of Appeals.
Yes, Your Honor.
So why did you not come directly to us?
Well, Your Honor, it is our submission that the Court of Appeals has jurisdiction. We will not want to burden the Supreme Court with a case where there is jurisdiction.
No,
in
concurrent
another.
yan.
Precisely, Your Honor, but the Supreme Court is busy with other cases, Your Honor, and in the principle of hierarchy of courts, Your Honor, the preference guiding post will be to file the case before another court with concurrent jurisdiction, Your Honor, in order to relieve the Supreme Court of the burden of having to act on a case that may be resolved by a different court, Your Honor.
Oh, we are used to burdens. Now, the point here is this. Do you have any statutory basis for choosing the Court of Appeals instead of the highest court?
Well, Your Honor, not statutory, but we have the guidance of the Supreme Court in the various cases where this court, in fact, in one case, chastised the Court of Appeals for failing to issue a temporary restraining order in the face of exactly the same facts that the respondent was preventively suspended for offenses allegedly committed in a prior term despite a re-election, Your Honor.
Oh, did you not violate the principle or policy against multiplicity of suits? When you marked time and went to the lower court before you expected this, of course, to come to this court.
No, Your Honor, we were in the Court of Appeals and we expected to be in the Court of Appeals because precisely the issues are before the Court of Appeals, Your Honor. It is the petitioner who chose to avoid the Court of Appeals and instead go straight on a 65 before this court, Your Honor.
Okay, let me just give you this thought.
Yes, Your Honor.
Section 4, Rule 65 is what gives you the instruction where to go. Thank you, Madam Chief Justice.
Thank you very much, Your Honor.
Justice De Castro and then Justice Leonen.
Can I ask Attorney Certeza to please go back to the podium? I just want to ask you about one point. It's about the issue of the matter being moot and academic. The matter of the TRO having become moot and academic.
Yes, Your Honor.
Don't mention anymore the status quo argument that you use because I've heard enough and read enough about it. I just want you to ask to answer these questions very briefly.
Yes, Your Honor.
What was being restrained by the TRO issued by the Court of Appeals?
The implementation of the suspension, Your Honor.
So it's not the issuance only, but the implementation.
Yes,
and
Your
the
Honor.
implementation of the preventive suspension will take how long? The implementation of the preventive
It is
suspension.
supposed to be for 6 months, Your Honor.
For 6 months. So the implementation of the preventive suspension was the one being restrained. It's not the outtaking of the vice mayor.
No, Your Honor.
So the preventive suspension is a continuing act and it will take 6 months.
Yes, Your Honor.
So is it relevant to consider that point when we decide whether or not the TRO has become moot and academic because the vice mayor has taken his oath? The oath taking took only a few minutes.
Yes, Your Honor.
It was done in a few minutes. So that is what has been accomplished.
Yes, Your Honor.
But the preventive suspension will take place for a long period of time.
Yes, Your Honor.
Do you think that is relevant to consider whether the TRO has become moot and academic?
Very relevant, Your Honor.
So you discuss that. I want the parties to discuss that issue.
We will do that, Your Honor.
Okay.
Thank you very much.
Justice Leonen.
Good afternoon, Counsel.
Good afternoon, Your Honor.
While I ask you some questions, would it be possible for someone from your team to put up on the screen Section 14 of 6770? Thank you very much. By the way, Counsel, is your client here?
No, Your Honor.
Not here, in the Supreme Court?
Not here, Your Honor.
In Baguio City. Is your client in Baguio City?
Not in Baguio City, Your
Is there
Honor.
any particular reason that he has not come up to face the highest court of this land?
I believe, Your Honor, that there
Because
was
the
no
Ombudsman was
order
here-
requiring his
The
personal
Ombudsman was
presence.
here during the last session. Is there any particular reason that he doesn't care to appear in the Supreme Court?
I believe it's not a question of him not caring or disrespecting the court, Your Honor.
So this is not something that we can use to say that the case is not important enough for him to deserve his presence.
I do not think so, Your Honor.
And this is not an indication of his interest also as to the results of this case
I do not think so, Your Honor.
or the respect for this court.
I'm definitely sure that our client
Is your
respects the
client
Honorable Court.
avoiding some pointed and direct questions that may be asked from him, from any member of this court?
I don't think so, Your
You see, I
Honor.
just recalled from the questioning of Justice Villarama towards the end part that he had very specific questions that I think the mayor of the city of Manila will be able to answer and not his counsel. But in any case, can you now therefore say under oath that you will speak for him and can bind him with respect to certain questions that we may ask of you?
Yes, Your Honor, as his counsel.
You are designated to speak on the matter of certiorari, I suppose.
Yes, Your Honor.
Yes. There is a supplemental petition that was filed by the Ombudsman raising the writ of preliminary injunction also as an issue in this case and asking for certain disposition of this court in relation to that matter. What is generally your comment with that supplemental petition?
Your Honor, we've looked over the same, although when we received it, we did not have time to prepare our written comment, much less were we given an instruction by the Honorable Court to file a comment, Your Honor.
Are you open that we open the issues in this case in order that we can fully ventilate?
To be candid to the Honorable Court, Mr. Justice, I
I
feel
suppose that you need
uncomfortable.
to be candid always to this honorable
Yes, Your
court
Honor.
and that you don't need to qualify a specific answer because we are hoping that under your oath you are always candid to this court.
Yes, Your Honor.
Okay, please continue.
I feel uncomfortable at this point because I have not truly perused the...
Wait a minute, you are lead counsel in this case?
Yes, because I prepared for the oral
And was
arguments.
the supplemental petition served on you?
It was, I think, only a few days ago, Your Honor.
But 15 justices have read the supplemental petition. It was also served on this court. And you are saying now that you are not prepared to argue.
I am ready, Your Honor.
Yes, on the supplemental petition, what is your present position?
I do not believe that the motion for leave has already been granted,
That's
Your
why
Honor,
we're
please.
asking. I'm asking you, what is your present position? Is your client now amenable to expanding the issues in this case so that everything will be settled, so that there is no need to come up here in a separate action?
I think during the last hearing, the Honorable Chief
Counsel, the
Justice...
question was very specific, and can I ask for a very specific
Oh,
response?
yes, Your Honor.
This is as courtesy to all my other colleagues because we are running out of time.
Yes, Your Honor. With respect to
In
the...
any case, now that you're not ready, let us proceed to other points. What is the nature of this present petition filed by the Ombudsman?
It is a petition for certiorari under Rule 65.
You agree with me that part of the requirement for a petition for certiorari is that there be a showing that there are no other plain, speedy, adequate remedy in the ordinary course of the law prior to the petition being filed?
Yes, Your Honor.
Okay, and does this include a motion for reconsideration?
Yes, Your Honor.
By the way, was there a motion for reconsideration that was filed by the Ombudsman with respect to the temporary restraining order and the writ of preliminary injunction?
There was none, Your Honor.
Was any exception alleged by the Ombudsman in its petition?
I do not recall.
Counsel, this is the case. This is
Before
precisely
the Honorable
case
Court.
that we are examining you on, and I just want to know whether you know that there is an exception that they allege.
There is, Your Honor.
I'm sorry, Counsel, but we expect, I would have expected more from you, having heard you speak in the media, seeming that you are very prepared to argue on all points. And here my question is very simple. What was the exception of the Ombudsman in relation to why we should consider this case and give it due course in spite of the non-filing of a motion for reconsideration?
The Ombudsman raised as justification the seeming confusion that was happening in the city of Makati, and she likewise indicated that there is a need to prevent the unlawful and oppressive exercise of authority by the CA, Your Honor.
And would you say that that is a valid exception to the non-filing of a motion for reconsideration?
We do not agree, Your Honor.
By the way, what was the nature of your petition in the Court of Appeals?
Rule 65, Your Honor.
Same.
Yes, Your Honor.
And would you say that one of the requirements is that there is no plain, speedy, adequate remedy in the ordinary course of law prior
Yes,
to the
Your
filing of the petition?
Yes, Your Honor.
So when did you file the motion for reconsideration against the preventive suspension order?
We did not file any, Your Honor.
You did not file a motion for reconsideration for the preliminary suspension order before you filed the petition for certiorari.
The preventive suspension order, yes, Your Honor.
And you filed a certiorari action.
Under Rule
And
65,
you're
yes,
now
Your
asking
Honor.
us to dismiss the petition of the Ombudsman because there is no motion for reconsideration of the order that they challenge.
The situations are different, Your Honor.
How is it different?
In our case, when we filed Rule 65, we were saying that there was no need for a motion for reconsideration, considering that the suspension was already impending, Your Honor, please. There was a clear violation of the law according to established jurisprudence.
And the TRO was also impending, in fact, there, and also that the writ of preliminary injunction was also likely to come because the schedule of the hearing was, if I remember correctly, March 30 and 31. That's why they came here. Is that not correct?
Yes, Your Honor.
So, the same situation.
I beg to disagree, Your Honor.
Again,
We are situated differently
why?
because we have relied on the fact that on our end, filing a motion for reconsideration will not serve and will not be the clear and proper remedy will not provide us with a proper remedy because of the threat that the suspension will be carried out.
And the threat to the power of the Ombudsman to preventively suspend was not there.
We submit, Your Honor, that there was no basis for the preventive suspension by the Honorable Ombudsman.
Please cover this carefully in your memoranda because it seems that both sides have not complied with the requirement that there be a motion for reconsideration that is filed first, and I would really appreciate if both you and the Office of the Solicitor General cover very clearly why your cases are different. Now, to move to
Yes, Your
another
Honor.
point, you are familiar with Article 8, Section 1, second paragraph, I suppose,
Article 8, Section 1
of the Constitution, I suppose.
Yes, Your Honor.
And if you have a copy of the Constitution or one of your colleagues can give you a copy, there is a second sentence to that paragraph. Which,
Yes, Your Honor.
I am sure that you have committed to memory, but just in any case. And it says, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess jurisdiction on the part of any branch or instrumentality of government. Are we on the same page, Counsel?
Yes, Your Honor.
Okay. Is that your source? Because in response to the questions of some of my other colleagues, you said that that is the source of the inherent power of this court to use the remedy of certiorari in these cases, assuming that Section 14 would be unconstitutional or null and void. Are you referring to that
Yes, Your
particular
Honor.
provision? How does that relate to the next section, that the jurisdiction of lower courts shall be appropriated only by law?
Well, We believe, Your Honor, that in regards to the apportionment of jurisdiction, that is the exclusive province of Congress.
And what about the inherent power or competence of the court to determine whether or not there have been grave abuse of discretion? Is that an inherent power or competence, a jurisdiction of the Supreme Court or of lower courts?
It is both, Your Honor.
Both. But in the second section, it says that courts lower than the Supreme Court, the jurisdiction shall be prescribed by law. Does that not imply that lower courts do not have inherent jurisdiction?
Inherent jurisdiction, Your Honor. Under Article 8, Section 1.
Section 2, it says that for courts lower than the Supreme Court, they may be created by law and jurisdiction shall be apportioned to it. Does that mean, therefore, that there is no inherent jurisdiction or competence of lower courts, and all lower courts will be created by law, and as it is created by law, statute will grant it its powers?
I believe that the statute will grant it jurisdiction, Your Honor, but not necessarily the powers.
I do not get your answer because it is not responsive to my question. Section 2 seems to say that courts lower than the Supreme Court shall be created by law, which means that they do not exist, which means that they do not have inherent powers because they're not created by the Constitution. As the law creates it, that is the only time that they are granted powers. Is that
Yes,
a
Your
correct
Honor.
interpretation?
Yes, Your Honor.
Therefore, there is no inherent power of a court of appeals for certiorari unless it is granted by law. Well, in our case, it is BP 129. It is very clearly stated that they have original concurrent jurisdiction on petitions for certiorari prohibition and mandamus. But that being aside, I just want to pursue some of the logic that you have stated in response to the questions of my other colleagues.
It is our submission, Your Honor, that the court's power, the lower court, as you referred to, Your Honor, they are really created
As the
by law. But
Constitution
once
refers
they
to.
are created
As
by
the
law,
Constitution refers to,
Yes.
not my category.
Yes, Your
It is a
Honor.
constitutional category, just so it were clear.
Yes, Your
because,
Honor.
of course, that we need to be textual.
Yes,
As I
Your
said
Honor.
in the past, this is a very political case, and the only fulcrum that we will have is to look at the law itself and be very clear about what it provides. Is that not correct?
yes, Your Honor.
Yes, and that is our only solace,
Yes.
in spite of the brickbats that may come out there. In any case, so therefore, looking at the Constitution, are you still maintaining your position that the Court of Appeals had the inherent power to act on this particular case, or only because it is granted by law?
May I explain my answer, Your Honor?
Please
My
answer
an-
first
Yes.
before you explain.
My answer is that the inherent power of the Court of Appeals lies in the very fact that it was created by law.
Created by law. So the law, the statute, gave it its powers, not the Constitution.
If I may respectfully disagree, the law created the
So
jurisdiction.
you do not agree.
Yes, Your Honor.
So you're saying that that second section in Article 8, where it says lower court shall be created by law, means that there are already existing lower courts. And we do not have to wait for a law for it to be created. Like the Court of Appeals did not need to be created by BP 129 and its jurisdiction defined, apportioned by that particular statute.
May I respond? Your Honor, it's our position that the courts, lower courts, are created
Because if
by
it
law.
is, if BP 129 is the power, is the source of the power of the Court of Appeals, it is statute, correct?
Yes,
Yes. And Republic Act 6770 is also statute, correct?
yes.
So the power of certiorari is limited by all the statutes read together. Is that not correct?
We submit, Your Honor, that with regards to auxiliary writs, these are part of the granted by the rule-making power of the Supreme Court.
Second paragraph of Section 14, clearly now flashed. No court shall hear any appeal that pertains to appellate jurisdiction, not auxiliary writs. Am I not correct, counsel?
Yes, Your Honor.
So we are not talking of Section 14, first paragraph. The second paragraph also states it's not about an auxiliary writ, correct?
Are you referring to the application, Your Honor?
No
Yes.
court shall hear any appeal. Section 14.
It is confined to an appeal.
Appellate jurisdiction.
Yes,
correct?
Your Honor.
So we read Section 14, second paragraph, in relation to BP 129, now saying that the Court of Appeals does not have jurisdiction over any appeal, correct?
Yes, Your Honor.
Except that portion has been qualified by jurisprudence. Is that not correct?
Yes, Your Honor.
Fabian versus Desierto,
Yes,
correct?
Your Honor.
Yes, and in Fabian versus Desierto, we said that does not apply for administrative cases with final decisions. The appellate procedure is Rule 43, not 65. This is not 43, this is 65. Only because before that provision was put there was no consultation or advice from this court. Is that not correct?
Yes, Your Honor.
And consultation or advice is not because we want to be consulted, but simply because the Constitution also requires it. Is that not correct?
Yes, Your Honor.
So in other words, you are now agreeing that the power of certiorari of the Court of Appeals is provided by law, statute, and is also qualified by statute.
Agree, Your Honor.
Okay, thank you. May I ask Attorney Olaso, Coronel? Thank you very much, Counsel.
Thank you, Your Honor.
Good afternoon, Your Honor.
May I dare ask you some questions in criminal procedure, because I am fully aware that you are one of the very competent professors in criminal procedure in the alma mater that we share with several other justices. May I proceed?
Yes, Your Honor.
In
Thank
criminal
you.
procedure, is there a difference between the investigation done by the police and investigation done by the prosecutor?
Yes, Your Honor, there is.
What are the differences?
Well, Your Honor, the prosecutor in the course of preliminary investigation is bound by the rules that establish particular pleadings that are required to be filed, as against police investigations, which can be based merely on experience, guidelines of the PNP, or other directives that are handed out by the
In other
superiors.
words, when the police does an investigation, they have a hint of a crime that has happened, but they haven't yet narrowed it down to the accused. They want to gather the evidence, identify it, preserve it, maintain it, so that during preliminary investigation, before the prosecutor, they're able to present it. Am I not correct?
That is the ideal situation.
So
yes,
at
Your
that
Honor.
stage, the police does it about almost ex parte. That because there is a crime that is reported to them, either by a tipster, for instance, an informant in a drug-related case, or some indication that a foul play has happened, that the police proceeds and therefore researches, examines the crime scene, looks at documents, gathers the evidence, makes sure that it is original document, object or evidence is also there, and so on and so forth. Am I not correct?
Yes, Your Honor.
And at the stage when the prosecution does it in preliminary investigation, there is already an identified accused. That
Yes,
the crime is almost clear. In fact, that the complaint already charges an offense. Correct?
Yes, Your
And
Honor.
that therefore, the elements of the offense can be laid down on the basis of the inference coming from the evidence that has been preserved, gathered, and presented before the prosecutor.
Yes, Your Honor.
So investigation done by the police is ex parte to a certain extent. Is that not correct?
To a certain extent, yes, Your Honor.
Yes. In other words, when the police investigates, there is no right to be present of anyone, even all those suspected of the crime while the police investigates. Is that not correct?
It may not be a right, but that may be resorted to by the
It
police.
may be, it's necessary, it may be helpful for the police that the suspect is there, but when investigation is being done by the police, sometimes it is helpful that the suspects are not there in
Yeah.
order that they're able to gather the evidence. Is that not correct?
Yes, Your Honor.
And in preliminary investigation, the right to be present is a constitutional right because the statute provides for it. Is that not correct?
Yes, Your Honor.
Yes, and that statute happens to be a presidential decree which has been adopted by the rules of court. Is that not correct?
Yes, Your Honor.
Yes. Now, we go to this case. Article 11, Section 13, subparagraph 1, of the Constitution. This is on the powers of the Office of the Ombudsman.
Yes, Your Honor.
If I may read to you, and I am sure that one of your colleagues has a copy of the Constitution, they could probably turn to this page. Or probably you don't need the Constitution because I know that you may have memorized it. But Section 13, subparagraph 1. The Office of the Ombudsman shall have the following powers, functions, and duties. 1 says, investigate on its own or on complaint by any person, any act or omission of any public official. Now, counsel, do you think that that investigate there refers to investigate similar to investigation by the police, or does that refer to preliminary investigation?
Well, Your Honor, by practice, Your Honor, the Office of the Ombudsman conducts a separate preliminary investigation from its internal investigation.
Yes, but we
Your
made a
Honor.
distinction already about preliminary investigation and investigation. This constitutional power granted to the Office of the Ombudsman to pursue public office as a public trust, to be able to do investigation, constitutionalized, put in the fundamental law, is that investigation that is preliminary investigation, or that is investigation in the sense of on its own that it has heard that there are corrupt public officials, or on complaint by any person, it moves in order that it tries to find the evidence, make sure that the accused is really guilty, because all of us know as public officers, it's very difficult to recover once there are rumors that you are committing a corrupt act. And therefore, the Ombudsman is given that power. So investigate there. Does that refer to investigation like the police or in preliminary investigation?
It could be like the police, Your
Like the
Honor.
police. So alongside that power to investigate, the Ombudsman should be granted the power to actually do queries. Is that not correct, counsel?
Yes, Your Honor.
Yes. And of course, because public officers are in position, in other words, they are holding public positions. And as holders of public positions, they are heads of offices. And as heads of officers, there is always the incentive to try to hide, delay, obstruct, or impede. I am not making any conclusion for your client. I am just saying that because we are lawyers, we look at the malicious extreme possible in interpreting the provision of law. Then therefore, that power to investigate includes the power to preventively suspend. Is that a correct assumption?
Well, Your Honor, the Ombudsman is granted other powers, Your Honor.
No, just preventive suspension. I want to go to the meat of the controversy here.
Yes, Your Honor.
Yes.
However,
So the power of the Ombudsman to preventively suspend in relation to any investigation is part and parcel of this textual power granted by the Constitution.
we cannot concede that completely, Your Honor, because the Ombudsman
Yes, but the
has
Office of the
other
Ombudsman
powers.
has the power to preventively suspend, although maybe in some cases there may have been ombudsman, what's the plural of ombudsman, in the past that would have abused it, etc. Correct?
Yes, Your Honor.
Yes. So we're just talking about the nature of the power of preventive suspension, correct?
Well, preventive suspension is not necessarily equatable to investigation, Your Honor. So I will hesitate to commit, Your Honor, that it is necessary for a investigation, Your Honor.
Perhaps in your memoranda, both you and the Solicitor General can cover the nature of preventive suspension as to whether it is simply granted by the statute or the statute clarifies a necessary power included within this concept of investigation in Article 13, Section 1.
We will do that,
That
Your
would
Honor.
greatly help clarify for us the positions that we will take in relation to the reliefs that you are praying for.
We will do that, Your Honor. Thank you.
By the way, in the 1973 Constitution, was there an ombudsman?
In the
73 Constitution.
The 73. Your Honor, it is the Tanod Bayan, Your Honor.
Yes, but did it have the same enumeration of powers?
No, Your Honor.
Yes. So only in 1987 did the Constitution say that public office as a public trust is such of fundamental importance that it is equated with such things as due process of law, equal protection of the law, because it is at the same level. It is contained in the same document. Would it be correct to assume that?
Well, Your Honor, the draft of the Constitution initially designated the Office of the Ombudsman as a constitutional commission.
Yes.
However, in the course of the deliberations, the framers of the Constitution sought
Made it as a
best
single
to-
power
Yes, Your
in
Honor,
order
an
that they can
office.
can move more effectively and efficiently, and therefore still a constitutional body.
A constitutional creation, Your Honor,
constitutional
but not
creation.
at the level of a constitutional commission, Your Honor.
Yes, but the principle, public office is a public trust, is a constitutional principle.
Yes, Your Honor.
Of course, you can always ask your lead partner in your law firm, Feli Aquino, who was a significant member who contributed to the deliberations leading to these provisions. Is that not correct?
Yes, Your Honor.
Yes. And probably why you are here before us now. Is that not correct?
Yes, Your Honor.
Yes. Okay. So we are saying that under the 87 Constitution, we have to consider public office as a public trust in crafting our doctrines in relation to the power of the Ombudsman. Is that not correct?
Yes, Your Honor.
And also in relation to our power. Is that not correct?
Of course, Your Honor.
Yes. And you are now assigned to argue before us on condonation.
Yes, Your Honor.
Do you recall of any case that granted administrative condonation that discussed the relation of Article 11 to condonation?
There is no case that discussed this.
No
However,
case at
this-
all, not a single one, not Aguinaldo versus Santos, not Salalima, not any other case.
No, Your Honor, because the latest case is a 2009 case, which already
So
in which
this court,
the-
when it ruled on administrative condonation in the past, did not consider this perspective.
Yes, Your Honor.
Yes.
However, it is deemed to have been
But it is
considered-
right for this court, as having individually sworn to the entire Constitution, to take the entire document in itself and do justice to the constituents who ratified it, and
Yes.
therefore consider Section 1, Article 11, Section 13, subsection 1 of the Constitution.
Yes, Your Honor, I would like to presume that the court in 2009, applying the condonation ruling despite the effectivity of the 87 Constitution, already considered this, Your Honor.
I mean, textually in the decision, was it part of the argument, the reasoning, the logic?
No, Your Honor.
No. Was it part of the issues raised by any of the parties?
No, Your Honor.
So was it really considered by the court?
Well, I would like to presume, Your Honor, that the
You
court...
are implying.
Yes, Your Honor,
Yes, and in
because that is...
crafting ratio decidendi from cases, we are not allowed to imply. Is that not correct?
Well, Your Honor, the
That's what
Supreme...
we teach our law students, correct?
Yes, Your
So
Honor.
that they are precise.
They are
So
precise.
that they are ready.
Yes, Your Honor.
So that there is creative space in order to accommodate contemporary circumstances.
Well, creative space, Your Honor, has to always be backed
Within
up
the
by
bounds
law.
of the law.
Yes, Your Honor.
Yes, okay. Now, let's look at Article 11, Section 5, subparagraph 5. I'm sorry, Section 13, subparagraph 5 of that same Constitution. There is also the power to suspend granted to the Ombudsman. Now, that power to suspend is different from preventive suspension. Am I not correct?
Yes, Your Honor.
That power to suspend by orders of the Ombudsman, upon recommendation of the Ombudsman, is already a penalty. Is that not correct?
Yes, Your Honor.
So, preventive suspension is not a penalty.
Yes, Your Honor.
It is a tool.
Yes, Your
It
Honor.
is ancillary.
Yes, Your
It is
Honor.
auxiliary.
Yes, Your Honor.
It is an accessory
Yes, Your Honor.
to what?
Well, to the investigation.
To the investigation,
Of the Ombudsman. Yes,
which
Your
is
Honor.
mentioned in the Constitution.
Yes, Your
Yes.
Honor, but not necessary.
Now, in Justice Carpio queried you on Annex D. And I suppose that you have also read Annex D, much as many of us have done so. Annex D, the entirety of Annex D, is that not
Yes,
correct?
Your Honor.
Yes. And in Annex D, you said that you read the docket numbers, correct?
Yes, Your Honor.
Yes. And the end of the investigation is both an administrative case and a criminal case. Is that not correct?
Yes, Your Honor.
And the Special Investigative Committee that was created was doing investigation a la Section 13 subparagraph 1 of the Constitution, correct?
Yes, Your
It was not a preliminary investigation committee.
It is already a preliminary investigation at
Really?
this point, Your Honor, because
Special
the-
Investigating Committee created in June of 2014
okay.
upon the complaint of Attorney Bondal, and thereafter leading to the recommendation to file cases.
Yes, Your Honor.
Yeah, so it was investigation like the police,
Yes, Your Honor.
which is a power granted to the Ombudsman, correct?
Yes, Your Honor.
So it started in June of 2014.
Well, that is the presentation made by
Yes,
the
the Special
Ombudsman.
Investigative Committee started in June of 2014, correct?
Yes, Your Honor.
Created by the Ombudsman, correct?
That is the presentation
Do you
of
recall the Ombudsman saying before this court, herself personally present, because she was a party and interested in the results of this case, and coming up here and making the time to appear before us, so that if we have any clarification, it's easy to call for her. And she said that there were progress reports that were submitted by the Special Investigative Committee. Do you recall her saying that?
Yes, Your Honor.
Do you contest that?
Well, I have no basis to say yes or
Will
no,
you
Your
traverse
Honor.
that?
Well, we have no basis to either
Yes.
say yes
So
or no, Your Honor.
it is probably not so accurate to say that just because the document was very long, Annex D, which of course took us a lot of hours to peruse, including the supplemental petition, the main petition, your position papers, we've read that. Even if we are not preparing to orally argue before this same court, we read all of it. We saw that there were instances when there were reports made to the Ombudsman. And therefore, it's not accurate to say that just the length of that report would be an indicator that the Ombudsman did not have sufficient time to examine the case.
Well, it was alleged to be just an indicator, Your Honor.
An
It does
indicator.
not make a conclusion.
And as we said the other time, this is a political case.
Yes,
and the
Your Honor.
Ombudsman knows that, of course,
Yes,
and
Your
also
Honor.
needs to be careful. And like many of us, we peruse things very, very carefully when we move through these cases, making sure that the facts and the law are with us so that we will not be accused of doing political curry for any of the parties. Is that not correct?
Yes, Your Honor.
Yes, and we could assume that the Ombudsman, being a very responsible official, and having been a member of this court, used to hundreds of cases, maybe even the thousands of cases at any given time, would know what to do with a specific case. Is that not correct?
I would think that is a fair assumption of the
Yes.
Ombudsman.
So
Your
what
Honor.
is now your basis for saying that she did not have proof of evidence of guilt as being strong?
Well, Your Honor, based on the ruling of this court on the condonation, Your Honor, that alone gave this court the opportunity to remind the Court of Appeals to aid in the wake of grave abuse of discretion committed by the Ombudsman when the Ombudsman failed to consider the fact that condonation is present.
There is the words there in Section 14,
Yes, Your Honor.
unless there is prima facie evidence that the subject matter of the investigation. Counsel, can you inform us what you know of the term prima facie
Well, on its face, Your Honor.
on its face?
Yes, Your Honor.
So the evidence on its face.
Yes, Your Honor.
Yes. That the subject matter of the investigation is outside the jurisdiction of the Office of the Ombudsman.
As an exception, yes, Your Honor.
As an exception. So, in looking at the evidence, the whole of Annex D, the Court of Appeals, in determining that based on the examination of all the evidence, is that prima facie?
Well, Your Honor, our position as regards this section, Your Honor, is that the prohibition refers to a TRO that will delay.
Oh, so you're saying that that clause does not apply to your case?
That is not the clause we are invoking, Your
Okay.
Honor.
You're saying that because in your position paper, you're saying that the TRO or the writ of injunction that should be issued should be to delay.
Yes, Your Honor.
Yes,
That
it
is
says
the
to
only-
delay.
Yes, Your Honor.
Which court will issue a TRO for the purpose of delay?
Precisely, Your Honor, that is the query posed to
So
the...
it will be an absurd interpretation of that provision to say that a court issues it to delay. Correct? Because no court of law in this country would purposely issue a TRO to delay. Correct?
Well, precisely, Your Honor. I think it is in the interpretation made...
So it is not the effect of delay, it is the purpose of delay. Correct?
Well,
It
Your
says
Honor,
there, to be issued by a court to delay, which means the purpose of the court must be to delay.
Yes, Your Honor.
Yes.
That is what is prohibited, Your Honor.
Prohibited.
Yes, Your Honor.
But it says, to delay, you may, if the prima facie evidence, etc. So are we saying that our interpretation of that provision is that courts in this country are allowed to delay?
No, Your Honor.
Purposively.
On the contrary, Your Honor, the courts should
Or
have
is
no
delay
intention.
there normative, descriptive, not normative?
Well, precisely what is clearly stated is that if the purpose is to delay, then it is prohibited. The second clause says that even if there is delay, if
No,
the
there is delay. It doesn't say there is delay. It says the court's purpose is to delay. Can we read
precisely,
it?
yes, Your
By any court to delay.
Yes, Your Honor. Precisely our proposition, Your Honor, our submission is that what is prohibited is for a TRO that is purposely issued to delay.
Yes. Can
Now-
there ever be a court of law that will purposely issue a TRO simply to delay the ombudsman? Isn't that grave abuse of discretion by its very definition?
Yes, Your Honor, precisely.
Isn't that arbitrary, whimsical, capricious on the part of a court, whether a trial court or a court of appeals or even this court?
Precisely,
Yes.
yes, Your Honor, precisely that
So
was the
to
question
delay there
posed.
cannot be read in such a way that that provision amounts to an absurd conclusion. Statutory Construction 101, is that not correct?
Yes, Your Honor.
Yes.
But precisely, Your Honor, our proposition is that this fact is being presented by the Ombudsman, that any TRO is issued for the purpose of delay, which is, to our mind, cannot be upheld by this court as a fact.
Can you agree with me that that word, that phrase, to delay, put in that paragraph, is an unfortunate turn of the formulation of that law, and therefore something that we need to interpret very carefully?
Well, our rule in statutory construction, Your Honor, prohibits us from construing a law that appears to be very clear.
Unless it is ambiguous and it would lead to an absurd result.
Yes, Your Honor.
Yes. So your position is that first paragraph does not apply to your client.
Not to the TRO of the Court of Appeals, Your Honor.
Yes. I just want to know what your position is.
Yes.
Is it that that first paragraph does not apply to your client, and therefore we will not measure the TRO or the writ of injunction issued by the Court of Appeals on the basis of the provision of that first paragraph?
Well, Your Honor, it is not our client, but it is the TRO of the Court of Appeals, to which this does not apply. That is our submission.
The writ of preliminary injunction, does that apply?
In the same token, Your Honor.
So what will be our basis for evaluating whether the Court of Appeals did the proper thing within its jurisdiction, not in excess of jurisdiction? What's our basis?
Well, this court, Your Honor, will have to await precisely the ruling on the matter of fact, of the factual basis for the preventive suspension, because this court has repeatedly ruled that is a question
That the
of fact,
Court of
Your Honor.
Appeals gravely abused its discretion in issuing the TRO and the preliminary injunction. That is the claim of the petition. Am I not
Yes.
correct?
Yes, Your Honor.
Yes. And of course, this is because it is a matter that is constitutional. The power of preventive suspension on the part of the preventive suspension on the part of the ombudsman is part of its power of investigation.
Well, that is a view.
Determines. Is it the ombudsman? Is it the court? Is it this court?
Well, Your Honor, this is precisely the issue before this court, I think.
Okay. Now let's go to the first paragraph is not applicable to you. That's your position.
Yes, Your Honor.
Yes. The second paragraph. We remove, no court shall hear any appeal. That's not applicable in our case. There is no appeal because
Yes,
there is
Your
no
Honor.
final decision.
Yes, Your Honor.
Either in the preventive suspension order, that's not a final decision, or in the writ of preliminary injunction, that's not a final decision.
Yes, Your
So
Honor.
that first clause is not applicable. But if we read it carefully, no court shall hear any application for remedy against the decision or findings of the ombudsman. Correct?
Your Honor, may I defer to Attorney Certeza, Your Honor?
Yes. You confirm as, may I refer to you as lead counsel, or is there a different lead counsel in this case?
I am the lead counsel,
Okay,
Your
thank
Honor.
you. You confirm that the position of the respondents is that that first paragraph is not applicable.
As it relates to an appeal, Your Honor.
First paragraph.
Oh, first paragraph, yes, yes.
Okay.
As
Now we
earlier.
go to the second part. We will not go into appeal because this is not an appeal. The factual ambience do not deserve this court's attention insofar as that clause is concerned. Now let's read it. No court shall hear any application for remedy against the decision or findings of the Ombudsman except the Supreme Court on pure questions of law. Does that apply to your case?
It does not, Your Honor.
Why?
Because the application being referred to
Are you applying for a remedy when you went to the Court of Appeals against the Ombudsman?
we were on petition under Rule
Were you
65.
applying for a remedy before the Court of Appeals?
If
Against
Your
the
Honor
Ombudsman.
is referring to a provisional remedy,
In order
yes.
to economize on time, were you applying for a remedy before the Court of Appeals against the Ombudsman?
Provision.
Appeal or application. It did not say and application, but said or application. So it is a conjunctive. Isn't that correct, Counsel?
Yes, Your Honor.
Yes. So no court shall hear any application for remedy against the findings of the Ombudsman except the Supreme Court.
On pure questions of law.
Yes.
I think, Your Honor, please.
So you availed
as
of the
it
wrong
relates- as
You
it
asked
re-
for remedy with the Court of Appeals.
Yes, Your Honor.
The law clearly states that only the Supreme Court can hear any application for remedy against a finding of the Ombudsman, and only on a question of law.
We do not agree that the second paragraph limits.
Are you saying that that provision is unconstitutional?
I am saying that it cannot be interpreted in the manner that
Is
the
it your position
Ombudsman is
that it is
advising it.
violative of Article 8, Section 5, subparagraph 5?
In the manner that it increases the jurisdiction.
No, I'm sorry, but Article
No,
8, Section
it's
5,
rulemaking.
subparagraph 5 is the power of this court to provide for rules of
Rulemaking.
pleading and
Yes, Your
procedure.
Honor.
Yes. Are you saying now, is it your position now that that paragraph does not apply in your case because it doesn't exist? It is null and void. It is contrary to the Constitution.
Because, yes, Your Honor.
That's your position now.
Yes, Your Honor.
You're putting that at issue.
Yes, Your Honor.
Okay. So, therefore, may I ask that that be covered in the memoranda of both the petitioner and the respondents in this case. Precisely, not only the first paragraph, as to your contention as to whether or not it applies, but likewise whether or not the second part of the second paragraph also applies. And your position now, and you speak for your client and as lead counsel, is that that is unconstitutional. So you put the question squarely before us.
Yes, Your Honor.
Yes.
We will do that.
Can I ask you questions on condonation, or will you defer to attorney?
I will defer to Attorney Coral.
Thank you, Your Honor.
Why can we not rule on condonation via Rule 65?
Well, the issue, Your Honor, on Rule 65 is clearly just on grave abuse, Your Honor.
The contention of the Court of Appeals was that the Ombudsman should not have issued the preventive suspension because there is this doctrine of administrative condonation. Is that not correct?
Yes, Your Honor.
Yes. And now they are coming up here, the Ombudsman is coming up here, saying that the Court of Appeals gravely abused its discretion because administrative condonation was not the point. The point was that it had the power of preventive suspension both for purposes of administrative cases and criminal cases. Is that not correct?
Yes, Your Honor.
Therefore, in this Rule 65, administrative condonation is squarely at issue.
Well, we beg to disagree, Your Honor. The condonation as a judicial policy remains in the statute books, Your Honor.
Now that you say it's a judicial policy, can you tell us whether this court can create doctrine without statutory or constitutional basis?
Well, Your Honor, when the court in 1959 issued Pascual, Your Honor, it adopted
No,
this
I'm asking you a
policy.
question of constitutional import. Can this court validly be a common law court in the sense that we just create doctrine because we want to create that doctrine? Or are we attached to text of both statute and the Constitution?
Well, Your Honor, part of the judicial power under the Constitution.
Legally demandable right, correct?
Yes,
And it
Your
says
Honor.
legally.
Yes,
And
Your Honor.
legally therefore means that there is a law or a statute or a provision in the Constitution, correct?
Yes, Your Honor.
Yes. So, therefore, when the court does that without any basis, then it creates bad precedent. Is that not correct?
Well, bad precedent may be bad precedent, but it is still precedent, Your Honor,
So,
on which the Court of Appeals
Aguinaldo,
may
the
rely.
administrative condonation doctrine, on what is it based? What is the textual anchor for administrative condonation? What law, what provision in the Constitution?
Well, the...
Perhaps you can cover that in your memoranda.
Yes, Your
because
Honor.
certainly I'm sure that the Solicitor General, going by the various pleadings that it has filed in the other cases, seem to challenge whether that exists at all, correct?
Yes, Your Honor.
Yes.
We are relying on the Supreme Court ruling that the power to forgive is part of the sovereign power of the people to elect.
Yes. If you know, or I don't know if this is Attorney Certesa's field of competence, why did Mayor Binay not vacate his post as soon as they were served with an order of preventive suspension?
This is a factual matter, Your Honor, that Attorney Certesa has better familiarity, Your Honor.
Yes, Your Honor. When there was a finding already, the issuance of the joint order, Mayor Binay consulted our team, and we recommended to him the proper legal recourse, which is to bring up the matter to the Court of Appeals.
There was an order of preventive suspension by no less than the Ombudsman served upon your client.
Yes, Your Honor.
Did the mayor vacate his post?
No, Your Honor.
Was there a TRO at that time?
Not yet, Your Honor.
Not yet. And what was your legal basis for making that? You're under oath, counsel.
Yes, Your Honor.
So, a lawyer, you are supposed to implement the law, no matter how good or bad it is for your client. Is that not correct?
Yes, Your Honor.
Yes. And there was an order for preventive suspension. Why was it not respected by your client?
The order of preventive suspension directed the DILG to implement.
Yes.
So there was a time
And the
element
DILG
involved.
actually implemented it by serving also a copy of that order on the City Hall and on your client. Is that not correct?
I believe that the...
Was this before or after the issuance of the TRO of the Court of Appeals?
I believe that
You see,
the
Counsel, I am
TRO...
concerned.
There were
because-
several hours
You see,
difference.
Counsel, I am concerned because there is a tendency of certain public officials in this country, especially elective officials, that upon the issuance of an order by a legitimate body, presumptively, there is an order of preventive suspension, that they will resort to people power and support that people power in blatant disregard of the legal authority that has issued that order of preventive suspension. That is my concern. That's why I want to ask you precisely, what was your legal basis for telling your client that he should not vacate the office in spite of the order and without a TRO?
Your Honor, we believe that the filing of a petition for certiorari between the
Does the
Court of
filing of a
Appeals
petition for
is the
certiorari-
proper remedy under
Does the
the
filing of a
circumstances.
petition for certiorari stop an order for preventive suspension motu proprio?
It does not motu
Yes.
proprio.
You have to wait for a TRO, correct?
Yes, Your Honor.
So was that good advice?
That we said that the mayor appealed to the DILG.
And because of
That
that,
if
there was
they will-
confusion in the city of Makati. Because there was an order coming from an authority, the mayor refused to respect it, you went to the Court of Appeals, you filed a petition, there was still no TRO, they implemented the order, there was an oath, then a TRO happened. Is that not correct?
I think the
So it was your
interim-
client that caused it all.
The-
No, I'm sorry, not your client. It was your legal advice.
No, Your Honor, I beg to disagree. The interim between the service of the TRO and the implementation of the writ involved a few hours only. And we take
And within
exception,
that
with due
hour,
respect, Your
even
Honor.
with a single moment, with due respect to you too,
Yes, Your
even
Honor.
for a single moment that there is no TRO and there is an order coming from a competent authority, lawyers are duty-bound to respect it. Is that not correct?
Yes, that's true, Your
Thank you,
Honor.
Counsel.
Justice Bernabe.
I just have one final question.
Yes, Your
Counsel.
Honor.
One of the requisites of an injunction is irreparable damage. Is that correct?
Yes, Your Honor.
Now, considering that the preventive suspension order is a preventive measure, what damage shall be caused by the implementation of the preventive suspension order? And if there is any, is that damage irreparable, considering that the law provides for the rule on succession?
Yes, Your Honor. We take note of the ruling of the Honorable Court in the case of Garcia, where it is said that suspension, whether preventive or as a penalty, will unnecessarily affect in a negative manner the decision of the electorate. So we are relying on that to present to the court that there is a damage here, not so much only with respect to the mayor, although he will be damaged, but also with respect to the electorate of the city of Makati.
That is notwithstanding the rule that the law provides for the rule on succession.
There may be, yes, Your Honor, there may be a rule on succession, but since in this case it is our submission that there was grave abuse of discretion attending the issuance of the preventive suspension order, we believe that under Article 8, Section 1 of the Constitution, we could go to the courts to seek relief.
Thank you very much, Counsel.
Thank you, Your Honor.
Justice Perez. And then I will ask.
Just
so that we can conclude the session.
Yes, thank you very much, Chief. Just for my own education, in the matter of the issuance of a preventive suspension order by the Ombudsman, is there any relevance? Is the concept of due process relevant? Or is it suspended because of the provisions of whatever law the Ombudsman would want to cite?
The due process clause here, I think, will not assume significant relevance, Your Honor.
So it does not enter into the picture. No issue of due process here.
I believe not, Your Honor.
Okay.
The issue before this honorable court is whether or not the Court of Appeals gravely abused its discretion.
Correct. But in the determination
And-
of whether or not the Court of Appeals gravely abused its discretion in issuing the TRO against the Ombudsman, that's not the issue of due process in the issuance of the actionable document, which is the preventive suspension order. Does it not enter into the picture? It is not a consideration whatsoever.
We believe that we are anchoring our defense in this petition on the fact that the Court of Appeals issued legally the temporary restraining order and WPI for the simple reason that the evidence of guilt is not strong, as we indicated in our committee.
Yes, and your conclusion that the evidence of guilt is not strong proceeds from what?
From established jurisprudence, Your Honor, and other factual considerations.
Only on that basis. Okay. Again, for my own education, there is one complaint which became the basis of both an administrative proceeding and a criminal proceeding. The criminal proceeding is for the determination of, in this proceedings, there was a fact-finding, a common fact-finding phase.
Yes, Your Honor.
Insofar as the administrative case is concerned, is the fact-finding phase itself the administrative proceeding proper? I say so because I see a distinction between what was the topic of Justice Leonen a while ago, that there is this police procedure fact-finding which should proceed to the preliminary investigation by the fiscal. And it's different. In the police investigation, no right to be confronted, etc., no right to cross-examine, etc., but in the preliminary investigation, magka-counter affidavit. That's why I'm saying in the administrative investigation, the fact-finding, does that correspond to the what is police investigation and a criminal proceeding, or is it the administrative proper itself? Because of another difference, that in the administrative proceedings, it is the ombudsman herself who will decide whether or not the respondent ought to be penalized. But in the criminal investigation, what is determined by the ombudsman is only whether or not a case can be filed before the Sandigan Bayan, and it is the Sandigan Bayan who will do the suspension.
Yes,
or are
Your
you changing, or you are disclaiming what the ombudsman said during last hearing, that in the criminal procedure there is no provisional PSO, and it is only in the administrative case that there is a preventive suspension order
There is no preventive suspension
in
with
the
regards
conduct
to
of the
the
preliminary investigation.
criminal aspect, Your Honor.
So, don't you find any difference between what happens in an administrative investigation and in a criminal investigation prior for purposes of filing a criminal case before the Sandigan Bayan, insofar as the question of preventive suspension is concerned? What I'm driving at is that, and I'll go back to my first question, in the issuance of a preventive suspension order in the administrative case, is due process not a consideration? Okay, I will not prolong this further because it's getting late. I'll just ask you, I request you to include this, if it matters to you, in your memorandum.
Yes, Your Honor. Thank you, Your Honor.
Okay, we want to conclude our session, so allow me now to be able to ask you. First, Attorney Certeza, you know the case of Buenaseda versus Flavier?
I recall, yes, Your Honor.
Oh, no, this is very, very important because it tells you about the due process rights in preventive suspension orders. Do you remember it now?
I'm sorry, Your Honor, I don't have the
Okay, none of you have that decision.
Bursuela.
Okay, this is a 1993 case, and if with the permission of my colleagues, I will read it. No, it's not there. Being a mere order for preventive suspension, comma, the questioned order of the Ombudsman was validly issued even without a full-blown hearing and the formal presentation of evidence by the parties. In Nera Supra, petitioner therein also claimed that the Secretary of Health could not preventively suspend him before he could file his answer to the administrative complaint. The contention of petitioners herein can be dismissed perfunctorily by holding that the suspension meted out was merely preventive, and therefore, as held in Nera, there was nothing improper in suspending an officer pending his investigation and before the charges against him are heard. Okay?
Yes, Your Honor.
Okay, please take this into mind when you are making your memorandum for both parties.
Yes, Your Honor.
Now, for the record, let me just state that 4 justices have voluntarily inhibited themselves as of this point. These are Justices Velasco, Brion, Peralta, and Hardeleza. And for the record also, the supplemental petition for certiorari was admitted by the court, and this already forms part of this case. Okay. Now, shall we go to the first slide? Defenses raised in the comment regarding the condonation, and this is your comment. In 2.23, clearly,
the alleged payments made to Mana and Hillmarks Construction Corporation in 2013 during private respondents' present term, meaning now, not before, executed by the present term were only made pursuant to the contracts executed by the City of Makati before or during the previous term of private respondent. As such, his subsequent re-election on May 14, 2013 absolves him from any supposed administrative liability during his first term. Okay, do you admit that? Okay. May I also read for you?
With respect, Your Honor.
Okay.
Since this refers to condonation, may I ask
Okay.
Attorney Coronel?
Okay, Attorney
Thank you,
Coronel.
Your Honor.
Also, in the petition for certiorari that you filed before the Court of Appeals, page 2, and I refer to the fourth full paragraph that starts with the word while. And I'm sorry we failed to capture that in the slide, but I'm reading from your petition for certiorari before the Court of Appeals, so you can actually confirm whether this is a correct reading of the same.
Yes, sir.
While some of the acts attributed to the petitioner were allegedly implemented during his second term as mayor, 2013 to 2016, the same relates to transactions, phases 3 to 5, concluded during his first term of office and therefore effectively condoned his administrative liability by re-election. You confirm?
Yes, Your Honor.
Okay. Therefore, you are saying all acts, all offenses are administratively condoned when they were committed during the first term because he was re-elected to a second term. Is that your theory?
Yes, Your Honor.
Okay. Now, on the present term, even if his acts are continuing, in fact, he made 2 payments during his present term. Because these were contracts entered into during his first term, they are also condoned. Is that not your theory?
Well, no, Your Honor. These acts are not alleged in the complaint, Your Honor. Filed
No,
before
they are
the
alleged in the
Ombudsman.
complaint, and I will flash that very shortly.
Your Honor, they are...
I will flash that very shortly.
Yes, Your Honor, that is raised in the appellate court, Your Honor. But these are acts which were not alleged in the criminal complaint, which was subject of the preventive suspension order.
So now
Therefore,
you're saying it's the criminal complaint that is the subject of the preventive suspension order?
No, Your Honor. The criminal
That is
complaint...
just what you said.
The criminal complaint includes the administrative complaint, Your Honor. There is only one complaint, both for the criminal and the administrative.
Criminal complaint and administrative complaint.
Yes, Your Honor.
Okay. These were found in the Ombudsman's complaint. In fact, these are attachments in the responses of the Ombudsman, and you never disputed the attachments of these documents. Is it not correct?
Yes, but these are not facts alleged in the complaint, Your Honor.
All right. So we will now go, because you keep on saying there is no basis for us to say that there was any payment during his second or present term. But let it be clear, you are putting it on record that whatever was committed during the first term, everything is administratively condoned.
Yes, Your Honor.
Now, whatever acts were committed during the second term, because they relate to a first term, they're also administratively condoned.
They are covered, Your Honor, by the
Yes,
ruling.
because that is precisely the exact. You would not have at all alleged that unless there was an act in the complaint that relates to an act in the second term. Is that not correct? Otherwise, that defense would be completely useless.
Yes, Your Honor, but that is alleged in the complaint
yes.
before this court.
Yes, you keep on saying allegedly. But remember, you are saying that on this alleged, whenever you come up with a defense of condonation, you are basically telling us, assuming arguendo, that the acts that were complained of were actually committed. That is actually what you're just saying. You are just not allowing yourself to present it in plain English by saying that the condonation doctrine already wipes out administrative liability. But you are basically saying, assuming arguendo that our client committed these acts, all of these offenses are administratively wiped out, correct?
Yes, Your Honor.
Okay, now to the next. So we now go against the specific allegations against Mayor Binay. with respect to the design and services contract. By the way, Counsel, are you trying to dispute that I read the documents?
No, Your Honor.
Okay. Are you also trying to dispute that the Ombudsman failed to read the documents before she issued the suspension order?
I have no basis to dispute, Your Honor.
Okay, so you are not disputing the fact that it is possible that I may have read the documents precisely because I ordered those slides to be put
Yes,
up.
Your Honor. We have
That
no
means
doubt,
that
Your
I know what I'm doing.
Yes, Your Honor.
Okay. And therefore, it seems to actually diminish the effort that we have been putting into our work when you kindly tell us that actually, humanly, we cannot go through voluminous documents.
That is not our intention or our
Okay.
submission, Your Honor.
And maybe because the Ombudsman also is known as a very hard worker, she may have gone through that also, right?
Yes, Your Honor.
Out of respect for her.
Yes, Your Honor.
Okay.
We have no reason to
The
disrespect.
first offense, RA 3019, graft, anti-graft and corruption, malversation, grave misconduct, serious dishonesty, and or conduct prejudicial. The acts, the approval of the payment to MANA for the third and fourth billings, voucher dated 28 November 2011 in the amount of 2,215,356. Are you disputing that this is part of the complaint?
I submit, Your Honor, that is.
Okay. Second act, disbursement voucher dated 24 July 2013 in his present term in the amount of 429,011.48. Is it not there?
It is there, Your Honor.
Yes. What are the evidence supporting the same? You want me to flash the PDF of all the evidence? Or is it okay for me to just read the titles?
It is okay, Your Honor. We have no disagreement with
Okay.
documents.
The evidence presented, sworn statement of Engineer Mario Hechanova, former head of the General Services Division and Vice Chairman of the bank. Supplemental sworn statement of Engineer Hechanova, contract for design and architectural services. Billing statements which showed MANA's progress of work, disbursement of vouchers, checks payable to MANA. Okay?
Yes.
Next set of allegations. Contract for the construction of Phase 3. Again, violation of RA 3019, falsification of public documents, grave misconduct, serious dishonesty, and or conduct prejudicial to the public service.
We confirm, Your Honor.
Okay, you confirm. The acts, issuance of the notice of award on 21 September 2010, execution of the contract with Hillmark on 28 September 2010, approval of the payments for Phase 3 from 2010 to 2011, evidence, affidavit by several publishers that there was no publication at all, certified true copy of the 1 December 2009 issue of Balita, affidavit of Lion Alana Abadilla, Vice President, classified advertising of Balita, all to the effect that there was no publication, contrary to the claim in the disbursement vouchers, disbursements despite irregularities, disbursement vouchers, checks, official receipts, bidding and pre-procurement without appropriation, City Ordinance 2010-A005, which validates it, that basically it's already awarded, notice of bidding conference, basically saying that they're not even going to conduct the bidding, minutes of the pre-procurement conference. Do you confirm this?
Yes, Your Honor.
Okay. Next, contract for the construction of Phase 4. Act of violations alleged. Violation of RA 3019, Graft and Corrupt Practices Act, falsification of public documents, grave misconduct, serious dishonesty, and or conduct prejudicial to the service. Acts complained of, issuance of the notice of award, execution of the contract with Hillmark on 18 August 2011, approval of payments, and from Phase 4 from 2011 to 2012. Evidence, lack of publication, affidavit that there is no publication, certified true copy of the page that was claimed in the disbursement vouchers that was the basis for the publication when in fact there was no such publication, bidding without plans and drawing, billing statements that shows that in fact there was no plans and drawings before the award was made, disbursements despite irregularities, disbursement vouchers, checks, and official receipts. Do you confirm this?
Yes, these are the evidence presented by the Ombudsman, Your Honor.
Okay, contract for construction of Phase 5, RA 3019, graft and corrupt practices, falsification, grave misconduct, serious dishonesty, conduct prejudicial acts, issuance of the notice of award on 6 September 2012, execution of the contract with Hillmark on September 13, 2012, approval of the payments from Phase 4 from 2012 to 2013, evidence, lack of publication, an affidavit, a certified true copy of the fact that there was no publication, contrary to what are contained in the disbursement vouchers, affidavit of the Vice President of Balita, bidding without plans and drawings, billing statements that show these, disbursements despite irregularities, showing vouchers, checks, official receipts, all made even without the necessary documents required before payments could be made. Do you confirm all of this?
These are the documents presented by the Ombudsman, Your Honor.
Are you saying that all of these acts, so many charges, have already been condoned because of Mayor Binay's re-election?
Only the administrative, Your Honor.
Are you okay? Only the administrative, which means Which means
that the government
there
may
is
still
no
proceed.
way that you can impose any administrative disciplinary measure on him until 2016, despite the evidence, despite the charges.
On the administrative, yes, Your Honor. That is our submission.
Okay, so he is immune.
No, Your Honor, because criminal cases may proceed against him, Your Honor.
Okay.
And the Sandigan Bayan may...
even if his acts are continuing, and should he still continue to make payments, all of those are administratively condoned, and he is immune.
No, Your Honor, if the acts do not relate to acts to mere deliverables in this administration, but are not tied to acts committed in the previous administration, then the Ombudsman may still pursue cases against him, both criminal and administrative, Your Honor.
Okay, as long as the incipients, no matter how criminal, in other words, it is both a criminal offense and an administrative offense, no matter how criminal, if the incipient act in approving a contract occurred during his previous term, the administrative act that follow from that criminal act are all condoned administratively.
Under present jurisprudence, yes, Your Honor.
Okay. Is this not tantamount to telling all elective officials who are in charge of billions of public funds that they can commit all forms of misconduct while they are in office as long as they ensure that they are re-elected, because they cannot be removed, fined, censured, suspended?
Certainly not, Your Honor, as I mentioned
So what
earlier.
is your theory? Remember, whatever we say here, in this case, on the matter of administrative condonation, applies not only to your client, but to all elective officials.
Yes, Your Honor, but that...
Yes, you are
Your
saying
Honor.
that you want this court to say what is good for your client is also good for all elective officials. So no matter how criminal the act is, they cannot be administratively disciplined.
Because it is administrative, yes, Your Honor, under extant jurisprudence, only the criminal
Now,
act.
we want to see how extensive the effect of your insistence that we continue the condonation doctrine will be on Philippine public law. Okay, so I want us to go through, point by point, through all the constitutional and statutory provisions that will be affected if we continue with your line of reasoning. Okay. A, constitutional provisions on public accountability, statutes providing for preventive suspension of elective public officials, statutes penalizing administrative offenses, effects on accountability of public officials, and I will show this one by one. Okay? We will go
Yes,
through
Your
this,
Honor.
and I want you to answer me. You were a former student of mine.
Yes, Your
With
Honor.
all candor and honesty, that this is the kind of legal regime you want us to continue to propagate.
We are merely following doctrine, Your Honor.
No, but we are saying that we believe that this is wrong. And you are going to tell us continue a wrong doctrine?
We are not saying that, Your Honor. In fact, we have conceded that this court may revisit this doctrine. What we are submitting, Your Honor, is that the Court of Appeals, in applying the extant doctrine,
But
did not
remember
really
that
abuse
when a matter
discretion.
is here for review, we can review everything from the point of inception, from the very first time that attorney or Engineer Bondal filed his complaint all the way up to the writ of preliminary injunction of the Court of Appeals. That is before us now.
When
And you
Your
cannot
Honor-
tell us we can only look at one issue.
Well, Your Honor, it is the rules that restrict the use of a Rule 65, Your Honor, restricts the...
Are you saying, like your answer to Justice Villarama, that when we are facing you, our students in law, we are facing you with the reality of the Constitution versus a rule of procedure, you will insist on a rule of procedure that will wreak havoc on our constitutional framework?
We are not insisting, Your Honor, on a rule of procedure. We are merely invoking jurisprudence, Your Honor.
Okay, let's go to the 1987 Constitution. Article 2, Section 27, the state shall maintain honesty and integrity in the public service and take positive and effective measures against graft and corruption. How can this court maintain honesty and integrity in the public service if we can say all elective officials just ensure you get re-elected and all your administrative penalties are wiped out?
Your Honor, the criminal action may be more potent.
Yeah.
In fact, the
Okay,
the
I will go to
Sandigan
that.
Bayan-
I will go to that. The administrative levels of discipline that can be imposed. Okay?
Yes, Your Honor.
But you have to face your own conscience. Remember, we are required to promote honesty and integrity.
Yes,
You
Your
have to
Honor.
review what you are asking this court to do. Article 11, Section 1. Public office is a public trust. Public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, and act with patriotism and justice, and lead modest lives. You're basically saying we can still maintain a straight face, keep fidelity to Article 11, Section 1 by saying all administrative liabilities are wiped out.
Because there is
Even
criminal
those
liability,
that have
Your
been
Honor.
committed during his present term.
Because there is still criminal liability that can be pursued by government, Your Honor.
Are you saying that the tenets of the 1987 Constitution should suffer because of this 1959 unfortunate doctrine that was made on legally insecure foundations in Pascual?
Well, Your Honor, this court has adopted,
You
reiterated
want
Pascual.
this court to give more importance to following the condonation doctrine than giving fealty to the Constitution.
No, Your Honor, we think they are not inconsistent, Your Honor. Precisely, this court may
All right,
revisit Pascual.
1987 Constitution, Article 11, Section 2, on impeachment. And impeachment is available for culpable violation of Constitution, etc., or betrayal of public trust. Okay?
Yes, Your
All
Honor.
other public officers, etc. So you understand that and how effective that is?
Yes, Your Honor. The
Okay.
criminal penalty
Public
includes
accountability.
removal from office, Your
1987
Honor.
Constitution, Article 9D, Section 2. Okay? On the COA, the Commission shall have exclusive authority subject to the limitations in this article to define the scope of audit, exam, establish techniques, etc., and prevent irregular, unnecessary, extensive, excessive, extravagant, or unconscionable expenditures. Are you aware of this?
Yes, Your Honor.
Okay. Ombudsman law, of course, Section 24.
Yes, Your Honor.
Are you also aware of other statutes that, not only in Section 24, provide for preventive suspension of public officials who are charged with misconduct?
Yes, Your Honor. The DILG has the power.
Okay.
The Civil
Now,
Service Commission.
With your condonation doctrine, you are now going to say that we are going to wipe out all of those statutes that provide for preventive suspension with respect to public officials that have been re-elected. Is that the message that you want us to deliver?
No, Your Honor. As we said, there is criminal liability that attaches, which is more potent, because it will include not only
you mean now
imprisonment
that
but
courts
removal from office,
All
Your
right.
Honor. I'm sorry.
Do you mean that Mayor Binay, because he has been re-elected, cannot be suspended by anybody?
He can be suspended, Your Honor, by the Sandigan Bayan immediately after the filing of
Administratively suspended.
That is covered, Your Honor, by the Sandigan Bayan suspension,
No,
Your Honor.
administratively suspended. Not
No,
in
Your Honor.
connection with the formal filing of information with the Sandigan Bayan.
Because of his
Nobody,
re-election.
as in nobody, the president and nobody. Once elected, nobody can administratively touch an re-elected official.
I think, Your Honor, this is precisely the fear raised in the view in Aldovino versus Comelec, the dissenting
Preventive
opinion.
suspension, local government code. Okay, section 63. Preventive suspension may be imposed at any time after the issues are joined. When the evidence of guilt is strong and given the gravity of the offense, there is great probability that continuance in office of the respondent could, notice, influence the witnesses or pose a threat to the safety and integrity of the records and other evidence. Precisely what the Ombudsman was saying. Okay?
Yes, Your
Are you
Honor.
now saying that this can never happen
No,
to
Your-
re-elected officials?
Well, Your Honor, the Ombudsman retains its power under Section 23.
This is the COMELEC. This is the local government code. I'm sorry.
Well, that is extant jurisprudence, Your Honor.
So because jurisprudence laid down in 1959 is still there, we have not struck it down, that is not available.
Unfortunately, Your Honor, the
That
court
is
may
not
have...
available.
Well, the court had the opportunity in 2009, but
Okay.
instead the court
But we
upheld.
never reviewed the Constitution. We never went deep into what the 1987 Constitution is demanding from public officers. We never did that.
We submit, Your
That's
Honor,
why
the
we are
court has the
saying
power.
that now the issue that is confronting you is the Constitution, all of these statutes, versus your claim that there is an unfortunate condonation doctrine.
Well, until this doctrine is struck down by the Supreme Court, Your Honor, we all as lawyers have no choice but to comply
Okay,
and abide.
even in the face of so many statutes that will have to be rendered ineffective.
Well, I think the Supreme Court...
Civil
accord-
Service Law, PD 807. The proper disciplining authority may preventively suspend any subordinate officer or employee under his authority pending an investigation. There is that. Section 41.
Yes, Your Honor.
Okay, if the charge is dishonesty, oppression, grave misconduct, neglect in the performance of duty, or reasons to believe that the respondent is guilty of the charge which would warrant removal from service.
Well,
Okay.
that is the dictate of this court, Your Honor.
Revised Administrative Code of 1987, Title 2, Paragraph A, Title A, Chapter 6, Section 51 on preventive suspension. The proper disciplinary authority may discipline any subordinate or authority or employee under his authority pending an investigation. Same provisions as the previous provision. You confirm that this is there. We are now going to say that this does not apply.
Only to re-elected officials, Your Honor.
Okay, now let us now go to the kind of administrative offenses that are penalized by suspension. Okay, Civil Service Law, PD 807. An elective official can engage in the following offenses and not incur any administrative penalty. He can be oppressive. He can commit disgraceful or immoral conduct. He can be inefficient and incompetent in the performance of official duties. He can be frequently incurring unauthorized absences. He can refuse to perform an official duty. He can be guilty of gross insubordination. He can conduct grossly prejudicial acts to the interest of the service. He can have direct or indirect financial or material interest in any transaction requiring approval of his office, and there is no administrative liability. Is that true?
Well, if there is no administrative liability, Your Honor, all the more that no administrative case may proceed.
See? So you cannot even file a complaint.
No,
That's
Your
your
Honor,
point.
a
You
criminal
cannot file a
complaint.
complaint. What will happen to that complaint? You just put it in the waste basket. You cannot file a complaint. You cannot preventively suspend. You cannot even impose
Your Honor,
the
it is not-
administrative discipline
it is not
because there is already re-election. That is the impact of
No,
your
Your Honor, we
statements.
are not saying that the criminal complaint must be thrown in the waste
I'm not
basket,
talking
Your
about
Honor.
the criminal complaint. That's another matter. I'm talking about the range of administrative penalties so our people can appreciate the fact that there are actually remedies in law, even for administrative disciplinary measures.
Yes, Your Honor.
Because if we uphold all your theory, we're basically going to have to say that with respect to all of those laws that were enumerated, and with respect to all of those offenses, and with respect to all of those administrative penalties, they cannot apply to re-elected officials.
Well,
That
unfortunately,
is what you are asking us to do.
we are merely asking the court to implement what is extant jurisprudence, Your Honor.
Okay. I will, let me just flash all the other slides because, okay, these are the very, very detailed provisions of all the laws that I had enumerated, including the Code of Conduct and Ethical Standards. We basically are going to have to say, just make sure you get re-elected, and there is absolutely no applicability for you with respect to a previous term. Okay? Okay?
And we can provide you, the other side, and the public, the slides of this, so they will understand what the implication of your position will be. Okay. Offenses penalized by removal, offenses penalized by suspension, offenses penalized by suspension again, many, huh? So many, and we will have to go through each one and say, except if you get re-elected, in which case you cannot ever be administratively meted this penalty. Okay, this is too long. It's more than 20 slides, all on the kinds of administrative penalties that are there. Okay? Now, all right. I want you to understand the full impact of what you're saying, because we cannot have a decision that only takes particular account of Mayor Junjun Binay and ignore the fact that the moment that we say condonation covers him, our courts will be deluded with all requests for TRO for preventive suspension orders issued by the Ombudsman, by the Civil Service Commissioner, by the President, by the Secretary of Interior Local Government, etc. You understand that?
Yes, Your Honor.
That is the practical effect of us upholding your position on condonation.
Well, Your Honor, if I may be allowed, conversely, Your Honor, this doctrine has been standing for more than 50 years. It can also be
Reviewed. That's why we want to revisit
yes, Your
it.
Honor. However,
Yeah.
the timing of its review 50 years later may also be seen as political, Your Honor, precisely why we are
Why are
merely
we going to be
relying...
political if we are trying to uphold the Constitution?
No.
You mean if we are going to push for honesty and integrity, we are going to be blamed for engaging in politicking?
No, Your
I
Honor.
thought that is what the Constitution precisely is asking us to do.
Yes, Your Honor. But as I said earlier, Your Honor, this court already had the occasion for the past 50 years.
But there was never a question about the Constitution's place vis-a-vis condonation.
Well,
Never.
that is also not
It is the only
presented in this
time.
case, Your Honor.
It was presented. It was presented front and center in the pleadings of the Ombudsman. It is now being presented here, and you cannot tell the court to please stop implementing the Constitution because it was not squarely raised. When we believe that our actions will lead to an erosion of the Constitution, it is our firm duty under the Constitution to uphold the Constitution.
Yes, Your Honor, but it will also abandon extant jurisprudence at the moment, which...
Many jurisprudence have been abandoned. That is why we review the past.
Yes,
That is
Your
even
Honor.
why we have motions for reconsideration. That is why we take into account contemporary construction.
Yes,
That
Your
is why
Honor.
we also take into account social and economic data.
Yes,
and I
Your
will
Honor.
now show you the financial data that is important. Okay,
Your Honor,
next slide, please.
May we also say that this is also the reason why we submit that there was no grave abuse of discretion on the part of the CA, because
I
it
know.
merely applied
I know.
50
Your
years
defense,
of jurisprudence.
your defense is simple in my mind. If the Court of Appeals just applied the condonation doctrine, then why blame it? If it applied a bad doctrine, why blame the CA?
That is grave abuse, Your Honor.
Okay. Now, the question before us is if we are going to listen to your insistent voice that procedures trump the Constitution. And now let me show you now the magnitude of the question that are in our minds right now and the impact that this decision will have on the lives of Filipinos for generations to come. Look at the next slide. This is from COMELEC data. I really thought that there were just about 40 or 30,000 elective officials. Confirmation from the COMELEC reveals that there are 690,502 for the 2013 elections who were elected. Could you believe that? I was just so shocked. So anything that we say here will benefit anyone among the 692,000 who are re-electionists, as well as anyone among them who will be re-elected in 2016.
With all due respect, Your Honor, I think it is not fair to presume that all 690,000 elective officials are going to plunder this country and get away by re-election, Your Honor.
Those are defenses available, and basically you're saying, look, what have you been saying all the time? Your client is innocent.
But we must avail ourselves of all defenses. So we're talking about defenses here. I'm not making an indictment against all the 690,502 officials, but they must know what administrative liabilities they are facing the moment they get elected and what will be their benefit the moment they get re-elected.
I am certain, Your Honor, that they are aware, Your
Okay,
Honor.
this is the magnitude. This is the magnitude. I'm not implying anything. I admire many elective officials. I admire them. They work through so much difficulty. But what we are talking about here is the wiping out of administrative liability by the simple expedient of re-election. That is the point. I'm not imputing anything else. Look at the internal revenue allotment of local government units. For the total amount that were distributed in 2015, look at that. 389 billion, 860 million, 429,000 were distributed in 2015. Maybe it's 2014. Or maybe 2015, I wouldn't know. Possible yan siguro. O to be distributed siguro. Total amount distributed in 2014, 341,544,726,000. Do you imagine the magnitude of that money? That is how much? That is nearly 40 times or 20 times the budget of the entire judiciary. Tama ba? More than times 20.
Well, I cannot presume, Your Honor, that all that money will go to
Hindi
politicians
naman
who
tayo.
will...
Hindi naman. I'm talking
plunder it
about
away.
local government units. Look, I admire local politicians. Why are you trying to tell me na that I am already presuming a lot? I'm not doing that. We're talking about the magnitude of the problem that we are facing here. And these are in terms of magnitude because the social impact of the message that the court is saying is very important for the life of this country. Okay. What do you understand about the internal revenue allotment? What are these?
Well, this is the share of the local government, Your Honor.
Okay. May I read to you Section 284 of the Local Government Code, okay? From which the IRA comes. LGU shall have a 40% share from the national internal revenue taxes on collection of the third fiscal year preceding the current fiscal year. And the manner of allocation, provinces 23%, cities 23%, municipalities 34%, and barangays 20%. All right? So this comes from who?
From the national budget, Your Honor.
National internal revenue taxes. Are they local revenues?
No, Your Honor, they are national.
Okay. So from which, from what people did this come from?
Well, for all citizens of the Republic of
All
the
the
Philippines, Your Honor.
Filipinos, all the foreigners paying taxes to the national government.
Yes, Your Honor. These are also the same people who are electing these
Okay.
politicians, Your
All
Honor.
right. Now, let's go to the cities with the highest amount of income. Quezon City, 12 billion. Makati is 11 billion. All right. So there is a proportion in the ERA law which defines how much of the ERA is going to be given. This is, I think, it's a local income. So that's not really, that's really tangential. But what is the point is that, are you now saying that the taxpayers all over the country are condoning the administrative liabilities of Mayor Junjun Binay, who was elected only by the voters of Makati?
I'm not saying that, Your Honor. I'm
But
merely
that's your
applying
point.
what the law, what extra jurisprudence says, Your Honor.
Okay, so you're saying, you know, I don't want to admit everything you are propositioning me to admit. Because I know it is bad. I know that I cannot in conscience say that all of these acts are condoned, but what you're actually telling us is, it's your fault, Your Honor. You are a lousy Supreme Court that had every chance to review the condonation doctrine, but never reviewed it. That's why we want to make up. If there was any problem that we had, this is our chance to make up. All right? Okay.
That is within the prerogative of the court, Your
Yes, and it is within the duty of this constitution of this court to promote honesty and integrity in public service, and because the Constitution is first and foremost our most important document and covenant that we must uphold.
Honor. As
Okay?
it is every citizen's, Your Honor.
So, all Filipinos, no matter how much they paid, if there is a malfeasance, if there is a gross dishonesty with respect to the era that was given to the city of Makati, their rights to an administrative disciplinary measure versus the officials of Makati will have to give way because Mayor Binay was re-elected. Are you saying that?
Well, they may pursue on the criminal as the Ombudsman
Criminal
is doing
only, but do not touch him administratively. You cannot even use the purpose of preventive suspension, which is to help the investigation, because the condonation not only prevents the imposition of the penalty, the condonation doctrine also removes preventive suspension as a tool in the investigation. See, you have a two-pronged argument. Don't use preventive suspension as a tool in investigation. Don't use preventive suspension as an administrative penalty because my client was re-elected.
Well, no, Your Honor.
And it is because you maintain a bad doctrine in your case books.
Well, we all do, Your Honor, until the Supreme Court changes its mind, Your Honor. We all have to,
I
as
know,
officers
that
of
is
the
what you
court,
have been saying
follow.
all the time. Your Honor, I know you are trying to say honesty and integrity are important, but it's your fault. That's what you have been telling us all afternoon. It's your fault.
No, Your Honor, there is another remedy, a legislative remedy, whereby Congress
Okay.
may, by
Okay.
legislation, enact a law that will address the issue of
All right.
condonation, including all the restrictions.
Okay, so we should be able to carve out exceptions to all those statutes because Congress is too silent. In the face of the Constitution, in the face of so many statutory provisions imposing preventive suspension, in the face of so many administrative offenses that are already defined, still, in the face of all of this, we have to abide by our 1959 doctrine that was based on bad case law.
Well, because Congress determines legislative policy, Your Honor. We
Okay.
cannot usurp legislative policy.
All right.
Your Honor.
On the social dimension, all right. Effect on the fight against corruption. And I want us to look at it from a social point of view and the effect on the morale of the Filipinos. 2014 World Bank Worldwide Governance Indicators. Okay? So, how would this affect our battle against corruption? Do you mean if we uphold this condonation doctrine, do you think that we will be perceived well as being serious in our battle against
Yes,
corruption?
because then we will proceed swiftly with our criminal aspect, Your Honor.
All right. Okay. No administrative penalty. Just proceed with the criminal. Don't suspend, don't fine, don't remove, don't preventively suspend, don't do anything administratively.
File a complaint, an information
So,
before the court, Your Honor.
if we want to fight corruption, this court will have to make a strong stand in favor of honesty and integrity. Okay? Transparency International. Okay? That's also there. Transparency International Global Corruption Barometer. I don't want to say and repeat all of those bad statements about the Philippines. Okay? All right? Okay? There were exceptions in 3 out of the 13 states. So if I ask you to shepherdize, I will ask you to give the constitutional context for all of these state cases, okay? Because I also, in fairness to the OSG, I also asked you to shepherdize. All right. And now this is the present state of the doctrine of condonation in the U.S. 17 states have rejected the condonation doctrine. And look at the reasons. What are more compatible with our Constitution? The reasons I find that these 17 states provide. Statute enacted specifically to include misconduct. Removal statutes are intended to protect the public and remove a corrupt or unworthy officers. Members of the public not aware of the misconduct. Misconduct during a previous term is a disqualification to hold a public office. A public officer elected merely continues his term. The new term cannot be considered separate and distinct from a previous term. Okay. Now, I want both sides, Because what I want us to do is to measure the Filipino soul. And I'm talking about the Filipino soul because I see this case as a measure of our steadfastness in trying to impose a spirit of honesty and integrity in public service. And I want you to look at Buenaseda versus Flavier again. So I want you please, both sides,
Yes, Your
to
Honor.
measure those doctrines against the Constitution, against the numerous statutes. I have decided, in other words, we want to have a contextual flavor so that this court can have a plan for moving forward.
Yes, Your Honor, we will
Okay.
do that. Thank you.
Buenaseda versus Flavier. You can keep on insisting that only a preventive suspension only affects the administrative complaint. Can you please read Buenaseda versus Flavier? Okay. And it's being flashed there. Next. I'm sorry, I'm running through this because I'm anyway going to distribute the slides. Please address this. Now go to Buenaseda versus Flavier, and meaning of the phrasing is the conclusion. Okay? Can you please read the conclusion?
Your Honor, the conclusion that can be deduced from the deletion of the word subordinate before and after the words in his bureau, after officer or employee, is that the Congress intended to empower the Ombudsman to preventively suspend all officials and employees under investigation by his office, irrespective of whether they are employed in his office or in other offices of the government. The moment a criminal or administrative complaint is filed with the Ombudsman, the respondent therein is deemed to be in his authority, and he can proceed to determine whether said respondent should be placed under preventive suspension.
Okay, in your client's case, what were the complaints all about? Were they not both criminal and administrative?
Yes, Your Honor, both.
So, is it not possible for us to say that in fact even the Ombudsman does not understand the extent of its powers and all of its officers here, because they keep on saying that the preventive suspension was only in relation to an administrative investigation, when Buenaseda was very categorical that it relates to both the criminal and the administrative aspect?
We beg to disagree, Your Honor. This refers to a criminal or administrative complaint. However, the law of the Ombudsman, Your Honor, and its rules specifically tackle preventive suspension only in relation to the administrative complaint, Your Honor, because the office that will have the right to preventively suspend on a criminal will be the Sandigan Bayan, Your Honor, after the filing of an
you can
information.
address that later on. But this is addressed to the Ombudsman. Maybe the Ombudsman's officers are not studying enough. Okay? Defenses raised in the comment. We have that. The first substantive defense of your client was condonation. The second was that the evidence of guilt is not strong. All right. Okay, in allegation 2.26, clearly considering that there was no basis to hold respondent Binay administratively liable, there could not have been strong evidence of guilt to justify the issuance of a preventive suspension order. Okay, do you affirm that this argument took place?
Yes, Your Honor.
All right. And then you say, in fact, petitioner simply relied upon the signature of respondent. Okay, that's the next. All right. Again, I will flash to you again the level of evidence that was considered by the Ombudsman, and we had gone through that already. All right. Design and services contract, contract for construction of Phase 3, contract for construction of Phase 4, contract for the construction of Phase 5. All right. We have two cases on evidence of guilt. Ombudsman versus Pelino and what is that? Ombudsman versus Evangelista, correct?
Yes, Your Honor.
Okay, now you're saying hindi malakas ang ebidensya. So, we are going to look at the evidence there. All right, compare the evidence. Pelino was accused of failing to disclose certain material information in her personal datasheet and SAL-N. In particular, the true and detailed report of her real and personal properties and the fact that she had a son. She was likewise charged with illegally acquiring and accumulating the following property investments, as well as incurring expenses and liabilities grossly disproportionate to her income and earning capacity as government employee, and not disclosing the same in her annual SAL-Ns.
The Ombudsman placed Pelino under preventive suspension for 6 months without pay for the following charges: 18 counts of perjury under Article 183, violation of RA 6713 in relation to paragraph 11 and 8, dishonesty and grave misconduct, and graft and corruption. All right. The evidence that were presented against Pelino here were the following: records from the Bureau of Immigration which show that from 1993 to 1994, Pelino and her son took 4 and 2 foreign trips each, respectively. Documents showing that Pelino acquired no less than 4 sizable properties. Pelino's 1986 to 1994 SAL ends. Okay. Compared with the more than 53 documents that were in the complaint of the Ombudsman, how does this pale in comparison?
Well, Your Honor, of the 53, Your Honor, none mention Mayor Junjun Binay, Your Honor.
Payments were made by him.
But the
Contracts
witnesses,
were signed by him.
the witnesses, Your Honor, which are which are relied upon, Your Honor, do not mention the Mayor Junjun Binay, Your Honor. Therefore, as against the evidence, Your Honor, precisely this is a question of fact, Your Honor. We again submit that this is within the CA jurisdiction.
The Supreme Court reviewed in Pelino and in Evangelista that precise question. And if we are going to look at the grave abuse of discretion by the Court of Appeals, and I'll show you how the Court of Appeals dealt with this question, we have to see and compare Pelino and Evangelista with the documents here. And in Evangelista, let's look at Evangelista. Okay, Mayor Ricardo Evangelista and 2 other officials of Aguilar, Pangasinan accused of having misappropriated the Special Education Fund, charged with grave misconduct and dishonesty before the Ombudsman. In the course of investigation, Mayor Evangelista et al. Were preventively suspended for 4 months. Okay? Court agreed with the Ombudsman that the following pieces of evidence were sufficient: status of appropriation, SARO, exactly the same documents there. Statement of income expenses, exactly. Sudden reduction of the SEF, exactly. Certifications that they did not receive speech kits nor textbooks. Same as the certification that there was never any publication. Local budget preparation form 151, which indicates the balances. Records from the office of the municipal accountant. Letter of Villanueva to the Miss Treasurer requesting clarification. Letter to Mayor Evangelista enumerating the disbursements. Okay. And what is the court's finding? There was evidence of guilt in strong enough measure.
But
Okay?
not, Your Honor, not for preventive suspension, Your Honor. This is a penalty, Your Honor.
All right, which makes my point stronger.
Well,
If
Your
in
Honor,
preventive suspension, if in for a penalty, that was already sufficient. With more reason for preventive suspension, that's sufficient. Because what is the rationale for preventive suspension? And let's flash this. In Evangelista, it said, preventive suspension is intended to preclude the public official from using his office to intimidate or influence witnesses. Precisely what the Ombudsman is saying. Tamper with records that might be vital to the prosecution of the case against him. Okay? All right. Okay. So, I want us to have a proportionate perspective because just imagine for us to ignore all of the statutes just because we had that unfortunate doctrine in 1959. You will have to take a constitutional proportionality test and put into context the duty of this court. You cannot keep on insisting, pasensya kayo, Your Honor, you made a lousy decision. Okay? We have to review things. And my last slide last 2 slides will just be the Court of Appeals. Okay, and actually I was very disturbed about how the Court of Appeals just very, very lightly dealt with this issue. Okay. In view of the seriousness of the issues raised, this is the TRO. In the petition for certiorari and possible repercussions on the electorate who will unquestionably be affected by suspension of their elective officials, the court resolves to grant the petitioner's prayer. Just that. Okay?
Yes, Your
Is
Honor.
that enough basis?
Well, the court merely heeded to the warning of this court when this court directed the CA
All right. If you want that, let's go to the WPI because there they had time to really look at the evidence and look at the CA resolution of April 6, 2015 on the WPI. Withal, in regard to the idea put forward by public respondent ombudsman that petition can still be pinned for his misdemeanor, available data thus far conveyed a different perspective from us, born of omissions in judicio from public respondent that payments were supposedly approved by petitioner. There was also no concrete and evidence of petitioner's participation in the annexes from both parties for the alleged incidents. They even did not go into the matter of whether the evidence that was already being put forward was strong enough in accordance with the Epelino and the Evangelista measurements.
Well, Your Honor,
Can they just do that?
The Court of Appeals conducted, in fact, oral argument on the
So
facts, Your
factual.
Honor. Yes, Your Honor.
Yeah.
And admissions were made by the Office of the Ombudsman's representatives
That?
before the Court of Appeals as regards certain factual matters that were asked of them by the court, Your Honor, which led this court to make a finding in the preliminary preliminary injunction. Nevertheless, Your Honor, the Court of Appeals still has the opportunity to rule
To correct itself.
because there
And
is still
correct
the main
itself.
case, Your Honor.
All right. Okay. Now, what I want you to do is to look at the context of the Constitution. And please, Counsel, do not make light of the Constitution. And do not just keep on pushing on us the blame for all of this mess.
That is
Okay.
not our intention, Your Honor.
Okay. So put the Constitution, the statutes, okay, the allegations, and weigh them because this court will have to make a careful balancing of the provisions. And that goes through also for the petitioners here, and they are warned to please study their own petition very carefully. So with that, I don't think we have any further question. You are given a non-extendable period of 30 days within which to submit. Yes.
If you are going to require memoranda from the parties, Chief, may I interject that I would need for my personal
Okay.
satisfaction a memorandum of authorities on both sides, no?
Yes, Your
On this issue of Section 14, the Ombudsman Act, that was the subject also of my interpellation during your time, as well as today. Particular attention to the second paragraph,
Yes, Your Honor.
okay? Because there are several points there, pure question of law, etc. And your contention a while ago, Rule 45. How
Yes, Your
could that be possible under the Constitution? Because of Section 5, Paragraph 2 of Article 8, which limits the remedy of appeal on certiorari to decisions of lower courts only.
Your
You enlighten me on that. I will focus on that. Thank you, Chief.
All right. Please include your comment on the supplemental petition. Attorney Certeza, you had the duty to make sure that you were ready for that petition, that supplemental petition. So unless there are any other clarificatory questions, we are now going to adjourn the session. Thank you. 30 days.